If Lord, may I be permitted to mention one contempt application for inclusion? Lord, if
Last week I have mentioned for reconstruction. Lordship, a report has been here, Lordship. The file could not be found, so I'm praying for reconstruction.
All right, we'll have a look today. You please wait. Show it today in chamber. Show it in chamber. Yes.
But may I permitted to mention, my lord, for inclusion of an application for restoration, my lord, in connection.
Give
Yes, my lord. I'm good.
Monday.
Yesterday, I wanted to ask, came and disturb your lordship, my lord, with respect to item number 11, 12, and 13. My lord, today also, my lord's endorsement is lordshiply taken up, my lord, from item number 1 to 0.
No, but I think we think you had come with the other side.
Yes,
We had told you that we'll take it up.
yes.
So are both of you here?
Not for the other side here.
Then
Possibly, my lord, I do not know, my lord, possibly for the endorsement in your lordship list.
no, that is a standard endorsement. But since both of you had jointly prayed, we had allowed it. Come tomorrow morning.
My lord,
Yes.
the lordship's pleasure, my lord, to at least, my lord, mention it in the
Mention it tomorrow. That we'll first take up.
great.
Mention tomorrow first. We'll take up 11, 12, 13. 11, 12, 13. 11, 12, 13. You want to mention?
my lord, my matter is at the top, my lord, number 1.
Item number 1.
Item 1, my lord, I appear for the petitioner. Mr. Arjun Rai Mukherjee is appearing for the respondents, my lord. My lord, my lord, matter relates to study leave of a doctor. My lord, if your lordship takes up page 41, this is the offer letter dated 18th of March 2025. Now, my lord, I got the offer letter. And if thereafter, my lord, immediately, my lord, I made an application on 19th before the competent authority, my lord, seeking study leave. That is apparent at page, my lord, it starts from page 46 from the format, my lord. Well, page 46 is the format it starts, and your lordship will find page 49, my lord, is the date on which I have made the application on 19th of March. Owing to this, my lord, if your lordship takes up page 44 and 45, I have given my lord, the requisite fees for the course and also my original documents which are kept with the authorities, my lord, with regard to my lord pursuing the course. But if your lordship takes up, my lord, page 38 once, well, this is the merit list wherein my name is appearing at serial number 7. And my lord, if your lordship also take note, my lord, somebody whose name is appearing at serial number 14, my lord, he is given the study leave. My lord, in my case, my lord, page 38, if your lordship takes up once, my lord. Page 38, my lord, your lordship may take, it's a notice dated 4th of March, my lord, second paragraph. The names of the candidates are arranged in a descending order of marks obtained in the entrance test they had appeared in. In case of a tie in score, the candidate who has chosen less wrong answers is placed higher in the list. Well, my name is at serial number 7. And your lordship, can you take note of the person whose name is appearing at serial number 14? Anup Kumar Boler. Lordship has got in, my lord. Well, if now your lordship takes up page 53, well, this person has been given the, well, the study leave to pursue the course. Well, with the condition that well, the candidates mentioned above will also render clinical services for patients' care in the institution where he is allowed to study. Well, I am, well, agreeable to such conditions, my lord. I mean, I will be in West Bengal, my lord, in IPGMR.
What is the urgency? That is what we are trying to understand. You
urgency-
go on leave, you pursue your study. If it is sanctioned, it will be sanctioned.
My lord, it
There
started.
is no requirement that it has to be sanctioned before you join the course.
My lord, your lordship, only thing, my lord, the urgency is this, my lord. In terms of the university notification, it says I have to be present for at least 80%, my lord, to complete the course.
Correct.
Unless, my lord, I am being granted a leave, my
Yes.
lord, I cannot just walk out from the institute where that I'm in. I'm in Shagudatta
No,
Hospital.
no, you cannot be unless you are granted. Study leave is not the issue. You can get leave otherwise. You proceed. Who is stopping you?
Your lordship, may kindly
The study leave is being considered by the tribunal. Maybe you will get it. We don't know. It's not coming in the way of your joining the course. Situation is the same as the other case.
well,
You
this-
go and join. It will be considered. It is pending before the tribunal. It will be taken up in August. We'll see. Maybe couple of dates. What will happen? We don't know. There's no dying urgency that it has to be done right now. Otherwise, you will miss the course.
my lord, subject
There is
lordship, kindly,
no
my lord,
scope for interfering at this stage.
subject lordship, kind consideration, my lord, and leave, my lord. I may say, my lord, subject lordship,
And
leave.
that rank means nothing. The person you are comparing with, he is in a different department. Maybe he is dispensable. You are not. We don't know.
That's true, my lord. I may say, my lord, absolutely,
That
your
does
lordship
not
is right,
mean
my lord.
anything.
Only thing, my lord, if your lordship may say, my lord, if I have to pursue the course, my lord, the other option is whatever is there is, my lord, to get an early leave or, my lord, EOL.
Yes.
My lord, your lordship may kindly grant us leave to file that application so that at least they grant, or else, my lord, they won't do anything.
What?
I have applied for study leave, my lord. I have not applied for EOL. My lord, if your lordship allows me to make a representation and
Who is
get the-
stopping you? Who says you can't do it? Unless there is something that requires to be removed from your way, why we should pass an order? You can proceed. When is the course to start?
my lord, it has started from 1st of April.
So you must be pursuing it now.
No, my lord, I'm been not been let out by the
Now for the last 3 months, the course has started. You are not attending it.
my lord, I'm not been, my lord. I have to get leave from, or I'm released from the Shagodatta Hospital, my lord, to attend the course. Shagodatta.
Page 46 apply করেছে।
I know, we couldn't-
Consider on. What is that? It is a common problem, not single problem.
Yes. Proceed on whatever leave is available. How have you been conducting the course since the last 3 months, 4 months?
No, my lord, I'm not getting released from my parent hospital where I'm in, my lord, Shagodatta Medical College and Hospital. Unless I'm getting released, my lord, I'm not in a position to either avail UL or
Issue
anything.
here is not your release. The issue is whether you will get a study leave for the course or not.
Absolutely, absolutely.
So therefore, we are not going to digress from the issue. Even if you don't get a study leave, nobody is stopping you from pursuing the course by availing the other leave to your credit. The issue is still pending consideration before the tribunal. Maybe the tribunal will grant you. Where is the question of us taking it up at this stage? That is what we are trying to say. Why should we?
Mr. My lord, but only thing, my lord, what they have done, my lord, in my case, my lord, neither they have allowed nor they have rejected. They kept the thing pending.
Obviously, that's why you are before the tribunal.
My lord, this been the
It is yet
situation.
to be
my lord.
considered by the tribunal.
My lord, this been the situation. Your lordship kindly grant.
Therefore, the tribunal has fixed it in August. It's hardly a month away now. The dire urgency that we have to assume jurisdiction when it is still pending before the tribunal to grant you a leave. What is at stake? What is the urgency? Nothing. So who is stopping you? Avail the extraordinary leave, whatever earned leave
My
in
lord,
the meantime.
your lordship may grant us only, my lord, I'm not replacing this, my lord, your lordship may grant us leave to file an application to grant AOL. My lord, unless your lordship passes, my lord, they won't do anything. My lord, your lordship has seen the matters with regard to doctors. My lord, even after your lordship's order, my lord, we have to approach this honorable court to get a resignation. My lord, this scenario would continue, my lord. I don't think, my lord, there will be any diversion whatsoever.
The petitioner. Yes, what do you want?
I want to make a mention, sir. Sorry for the late, sir. There is heavy raining, sir.
Yes,
I come from Pune, sir.
yes.
On the last occasion, unfortunately, I did not get interim relief, sir. This is matter regarding premature repatriation. Therefore, I went to Pune and joined in my parent department, sir. Now, I come to Calcutta for filing affidavit in reply, sir. There is a problem. Some of the officials have told affidavit in reply has to be submitted before the bench, not in the registry, sir. That's why there is no urgency.
No, you go and file it. They will accept it.
They are not accepting.
We are telling you, go and file it. They will accept it. You give the case number. You go and file it.
Okay, sir.
Yes.
One more thing, sir. But liberty has been given. There is no further date has not been given, sir. Any date may kindly be given on the next month, sir.
File it, then we'll see. Tell them to accept. It will be accepted. Go and file it.
No, sir. When I have to come again for Kolkata, sir, for Pune, there is no.
See, your other side is not here.
No, sir. This is the order of the coordinate bench of this court, sir.
The other side is not here. How can we fix a date in their absence?
No, next month, they did, sir. I will convey.
You are the writ petitioner.
Yes, sir. Petitioner in person, sir.
Let us see the last order.
Yes.
File it, list this in the next month. Give a date in the next month, after 3 weeks.
Sir, any fixed date may kindly be given, sir, so that I can convey my date of hearing, sir. And if I will not get leave from my parent department, I will appear through video conferencing, sir.
You should take consent from the person before you mention it. Who is the learned advocate appearing for the other side?
Sukanta, sorry, sir. Sukanta Chakrabarti, he is the contesting party, sir. I will inform, yesterday I have already informed him, sir.
That you are
About
mentioning today.
mentioning, sir. Yes, sir.
So tell him, give the date for after 3 weeks. Give him.
If there is any possibility, it may be given in the next month, sir. I will 21st? Okay. Thank you very much.
Item number 103.
I put for the petition in this matter.
I am for the respondent, Lordship. Yesterday, Your Lordship was extensively heard out the matter, and my preliminary submission was that, Malit, the issue of the adjudicating the 7A was within the ambit of the quasi-judicial authority, number one. And the warning letter which was issued on 3/4/17 and the charge sheet dated 17/8/2021 is having the common phenomena
My lord, I have to
pertaining to
show-
the 7.
I have to show, because my lord, he has
And for
started,
that,
I have to show, my lord.
No, you have to show nothing. We had asked him.
Acha.
How do you sustain the order?
yes,
We had asked.
if Your Lordship will go to their reply filed before the Central Administrative Tribunal.
We want to see how you sustain the order. We are not hearing the matter. We are looking at the correctness of the judgment or order passed by the tribunal. It says because it is for the same, it cannot be done. How it is the same?
Yes,
Tell
that,
us.
that thing
That is
can,
the only thing.
that thing can be ascertained from the reply, Malit. And they are
No,
pleading
it
itself.
cannot be. It is
Kindly come-
relying on one document only. The tribunal's order 3/7/2017.
3/7/2017.
Let's see what 3/7/2017 is. It's for a totally alien issue. Has nothing to do with the issue being
Page
considered.
29.
Malit, kindly come to their pleading, Malit. Their petition. What they are saying.
We are not concerned. We are on the
So they have
correctness of
dealt
the
with-
tribunal's order, sir.
They have dealt with that point. Kindly come to page 300, Your
Who
Lordship.
has come to, who has dealt with that point?
They have taken this particular plea, and the tribunal has also gone into the merit of that particular pleadings, which was before the tribunal by way of the
We
affidavit.
are asking you one question.
Yes, ma'am.
The tribunal has relied on one document.
Yes, yes.
Relying on that document, it says the issue has attained finality. Therefore, we will not permit it to be de-agitated. That is the order of the tribunal. Is there any other ground on which the tribunal has interfered? Show us.
The second ground they have taken,
Show us. See, they may have taken 1,000 grounds. That is irrelevant. We are trying to see how the order is sustainable. Therefore, we are asking you, is there any other ground taken up by the tribunal to pass the order?
no, Alex. The only thing they have dealt with
Nothing
the
remains. They may have taken 100 grounds.
and the second
That
point
is
which I have taken,
immaterial.
Ballot, since they are performing the quasi nature of job,
It is
so therefore,
immaterial.
Ballot,
There is no judgment on this issue.
no, Ballot, I'm covered by that particular point.
No, you may be covered, but the tribunal has not considered it. Why should we go into that? You have not argued. You have obtained an order on this point only. You are happy with it. You could have argued the other points, which you have chosen not to do. Therefore, we gave you time because it's a voluminous order.
Yes.
Whether there is any other ground urged or considered by the tribunal.
That
If
is the
no-
part, that is the delay, Ballot. That is the second point that the tribunal has considered on a point of
Let us
delay.
see where is the conclusion on the delay aspect. Come to the tribunal's order.
Only 2 points I'll place, my lord. Kindly go to that page 269 of the order impugned, my lord.
Can you give the internal page of the order?
Internal page, your lordship would go 29.
20.
29.
Yes. No, this is taking note of the steps. See, you cannot, we are asking you whether the tribunal has considered any other aspect to pass the order. It may have taken note of 100 submissions. His order has been passed on only one aspect. That is all. That's why it has repeatedly, it has
Order
taken
has
note
been
of.
passed taking into consideration of the 3 aspect, my lord. The one of the
Show us
aspect.
the finding of the tribunal. Don't show us what the submission was.
Yes,
That is totally irrelevant.
Shall you go to internal page 42, your lordship? May I read, my lord?
42, just let us.
Internal page 42 of the running page
Yes,
280.
in the present case.
In the present case, I discussed herein above, and more particularly admission on the part of the respondent, that in the year 2015, the disciplinary authority, competent authority, has received the complaint against the applicant for not finalizing the 7A proceedings and had not passed final order after conclusion of the 7A proceedings for a period 10 to 14. Undisputedly, the said lapse on the part of the applicant was made known to the competent authority in year 2015. Not only that, in respect of the said lapses, investigation was ordered to be carried out by the competent authority, and in receipt of the vigilance report, it has been found that there is no vigilance angle in the complaint, and by accepting the reply justification, the then disciplinary authority was authority with the approval of the competent authority by treating the lapses as an administrative lapses, has taken to conscious decision not to initiate disciplinary proceedings with a order dated 3/4/2017 that your lordship has gone into.
This is a perverse finding. This is a perverse finding of the tribunal.
So that your lordship is adjudicating, my lord, because I am pressing the things which is in my favor.
3/4/2017. Just see whether it has taken into consideration this aspect.
3/4/17, my lord,
Yes.
the second paragraph, or
Yes.
once your lordship will go into the second paragraph,
Yes.
there is a whisper, not whisper, there is a candid submission on the part of the 7A proceedings, my lord. Kindly come to page 30. It is not that it is not discussed. It is discussed, my lord. I'm reading, my lord.
Page 30.
Page 30.
See, you have just now placed one paragraph where it says the vigilance report found that there is no vigilance angle in the complaint. By accepting the reply, justification of the then disciplinary authority with competent authorities approval, treating the lapse as administrative lapse, has taken conscious decision. This he is talking about the lapse. This is not discussed in 3/4/17. We have gone through it yesterday. This 7A issue is not there.
I'm reading, my lord.
Page
30 itself, my lord. Sri Pandey was denied by him. The investigation into the said allegation suggested action against him for certain lapses, especially failure on issuing final order after concluding inquiries under Section 7A of the EPFO Act 1952. 30.
Find the
30.
page. 30 of what?
30 of the volume 1, so that is the 3/4/17 letter which your lordship has already gone into the merit yesterday, lordship.
There is a paper book also.
Yes.
Not giving the paper book.
Volume 1.
You are not giving the paper book.
এটা মনে রাখবে কোথায় আমি ই করছিলাম Have you also got it? Yes. Then after second paragraph, there's segment on careful examination of the allegation, reply of the officer, and finding of the investigations, a competent authority has decided that though formal action by way of the institution of disciplinary proceedings need not be taken, warning may be issued. So disciplinary authority under Rule 10(2) was having the opinion that the latches on the part of the charged officer or the respondent herein is not tantamount to circumvent the disciplinary proceedings. There was a latches and the warning was suffice pursuant to the opinion of the disciplinary authority, my lord, which subsequently after 4 years, under the PITP complaint and the decision of the vigilance, the disciplinary authority's order condescend to the extent that they have the decision of the vigilance superimposed the decision of the disciplinary authority, my lord. And they are also stated in their reply before the tribunal, my lord. Seven. Thereafter, I'll pray to implore the page 47, your lordship. What is the advice of the CBC? Concentrate act. Hence. Yes. Page 30, no, at the
Page 30 takes into consideration an investigation by the Vigilance Wing Zonal Office. This can't be that document, page 47.
So that this pilot happened in 3/4/2017.
Correct.
This is the letter, the warning letter. This Vigilance Commission letter dated 3/3/2021, subsequently thereafter. Now I'm reading the statutory provision, my lord. What tells about the rail 10.2?
Now,
This
please
10
come again to page 30. Please try to answer our question again.
Yes, my lord.
There is a reference that an investigation was done by Vigilance Wing at page 30.
Yes, my lord.
Where is that report of the Vigilance Wing?
This report is not before me, my lord. This is not before the tribunal, my lord. It was basically once the disciplinary authority has considered and passed an order of warning. So therefore, my lord, that matter ends at that point of time.
The disciplinary authority has passed an order relying upon the investigation by the Vigilance Wing.
Yes.
While the allegation leveled against you were denied, the investigation suggested action against him for certain lapses.
Yes.
So therefore, what is this Vigilance Wing report? Where is this Vigilance Wing report?
That
Page 30 refers to a Vigilance Wing report.
yes.
Where is that?
page 30 refers to, but it has not been, my lord. It is not there.
It's not in the record.
It is not in
Have you gone through it? Such a voluminous
Not,
thing.
but my lord, if your lordship, it's not the page, just this one, my lord, the office memorandum, but CVC. CVC, if your lordship kind of takes note, all has been taken care of. If you can.
How it can be taken care of? It is of 21. What are you saying?
Yes, my lord, it is of 20, it is of 21, right?
Then how it can be taken care of in 2017? Please try to see things before you make a
No,
submission.
I'm not saying about 17.
We are saying about 17 and you are taking us to 21 as if that is the answer. How can it be an answer? It appears from this prima facie we are of the view, we don't know, we may be wrong, that these 7 complaints resulted in these 8 allegations which have been enumerated at page 29.
Yes.
These 8 allegations were inquired by the Vigilance Wing. Action was suggested that action was not suggested. But certain lapses, especially this 7 issue has cropped up during that Vigilance Wing investigation.
Yes.
And therefore, they have proceeded on that.
Exactly, my lord. Now the 17 is there. After letter of the 17, my lord,
Yes.
if your lordship go by the statutory provision, what it says, whenever the disciplinary authority is of the opinion
Yes.
that there are grounds for inquiring into the truth of any imputation of misconduct or misbehavior against an employee,
Yes.
it may itself inquire into or appoint under this rule an authority to inquire into the. Pause for a moment.
Very common.
Now the 17 letter
Yes.
is the substantial one for the disciplinary authority to take the call, and on the basis of the formation of the opinion under rule 10.2, he thought, or rather he was having the mind that these are the administrative lapses, so therefore warning may be
He was
suffice.
not. That is why you are either we don't know how to explain to you. At page 29, there are 6 complaints.
Yes.
None of these 6 complaints are regarding any order passed under 7A. The 6 complaints are clear
Yes.
as to what imputation and allegations arise from the 6 complaints,
That's right.
which are enumerated at the second half of page 29. These 8 allegations arise from the 6 complaints.
Yes, Bennett. Now go to page 30.
Yes, that is what we are saying. Now go to page 30.
Yes. 30.
Regarding these 8 allegations, they say nothing is required.
Yes.
But during course of investigation, they have discovered that some orders under 7A were not passed
Yes.
or delayed.
Yes.
For that, this is not the order because that was not under consideration. Therefore, we are asking where is the Vigilance Wing's order, the investigation report?
I draw my inferences on the basis of the discussion in a penultimate paragraph, pilot,
Correct.
which the authority has taken to consideration of the
We are
delay or
also
latches of the
we are
7A.
also drawing our inference from that only.
Yes.
Because this document has to be read as a whole.
Yes.
The document as a whole is clear in its expression that there are 6 complaints resulting in 8 imputations and allegations. Inquiry by the Vigilance Wing Zonal Office says not required. But in that process, they have stumbled upon some 7A lapses. That is not covered by this report. Prima facie, that is our view. Maybe the vigilance wing report says that yes, this is also an aspect there, but nothing is
No,
required.
but your lordship will go to the last paragraph, my lord. What after considering discussing the 7A
Yes.
procedure?
Findings of the investigation, sir, that is precisely what we are saying.
No, this is the decision of the competent authority, that is the
You
disciplinary
read it.
authority.
You read it.
Therefore, Sri Pandey, Regional Providential Commissioner, is hereby warned to be careful in future in the discharge of his official duties
For what?
for the 7A
For,
latches.
for all his duty he has committed till date, or for the allegations and imputations which were pending consideration or which have been considered.
That is including the 7A
So
procedure.
that it doesn't appear to. Because 7A proceeding is neither one of the imputations and allegations at the bottom of page 29, nor it is stated in
Yes.
the
It
grievance.
can be ascertained by the reply, my lord, what they have stated in the tribunal.
No, it can be ascertained by the Vigilance Wing Zonal Office report. This was investigated by the Vigilance Wing Zonal Office, Patna and RO Patna. This is the report relying on which this order has been passed. If this report, we don't know, it may have taken into consideration that apart from these 8 imputation allegation, there is some issue of non-passing or delayed passing of orders, but we don't think anything is required. Maybe. Or it may be that yes, all this is not required to be pursued, but we have found this also.
I got your lordship's point. Now, in order to satisfy your lordship query, I just want to produce their reply before the tribunal.
Let
what they've
us see.
stated.
Let us see.
Yes, kindly come. Yes. Kindly come to page 183.
His official duties are these. Official duties is to be covered. No, no, it is covered. We should be. Yes.
Yes. Kindly come to page 183 onwards, my lord. Just, I'm trouble your lordship to read to
183.
183. That is volume 2. What they have stated before the tribunal, my lord.
This is their reply.
Yes, that is the department's reply, my lord. Which was
Just let us read.
just 3 pages, my lord.
Yes, we have seen it.
The same point they have taken at page 300 of this writ petition.
Yes.
So therefore, my lord, the 4 to 6 complaint as well as 7A was a part of consideration before the authority at the time of the issuance of the warning, which subsequently under the guise of the CVC recommendation, the charge sheet was framed, which is in violation of the rule 10.2, because by virtue of that, the opinion of the disciplinary authority has forced to change. The authority of the disciplinary authority has condescended to the CVC. And it is admitted fact pallet, the adjudication was within the ambit of the 7A, which is quasi-judicial in nature. And I'm relying upon the two judgments of the Honorable Apex Court, my lord, wherein it has been categorically held a person who is performing the nature of the quasi-judicial authority, if there any latches or any wrong order, that cannot be.
Wrong order is a different
Yes,
thing.
that similar fact, my lord, similar fact.
Wrong order is a different thing. Not passing an order is a
Here,
different.
my lord, this is not a matter because there is a no whisper about my integrity. There is a no whisper about any extraneous consideration. The points of the non-passing of the 7A was provided to the discipline authority. Some of the impediment was there. The Patna High Court matter was going on. The employees has
All
not
the cases.
no for the 7A.
In all the cases, there was
Most
an
of the
order.
case, because there was what was the order in order to ascertain the employees detail, and the company was not providing the employees detail. So therefore, my lord, and for that reason, the contempt was also pending before the before the Honorable High Court at Patna.
So therefore,
these-
that was an issue which could have been considered by them in the inquiry.
Therefore, I have participated, my lord.
No, you have not. You
I
have nipped it in the bud. The charge memo is gone.
Because charge memo, I constrained to file the charge memorandum on a two ground. For that particular aspect, you have issued the warning, but subsequently, in order to satisfy the CBC aspiration, you issued the subsequent charge sheet
was
after
not-
the 4 years, 5
So
years.
what is your submission? It could not have been done, or it could have been done independently.
Well, that is,
Either you are saying it was at dictates of CBC,
yes.
or you are saying it cannot be done. What is your submission?
No, my submission it is dictate of the CBC, and that is violation of the Rule 10(2).
So that is your submission. It's not your submission that if it was done independently, it could not have been done. If the CBC had not given any such direction and the disciplinary authority came to a view that no, we should not have let it go like this, would they have done it?
My submission would be valid because that is because I am relying upon the statutory rules, and the Rule 10(2) is very clear.
All
about
right.
their
So
verdict.
therefore, your point is this. Let us see 10.2. Where is 10.2? We have got this control and appeal rules. Yes.
EPF. They have a separate. That is only mutated to the CCA rules, valid. Okay.
So on this ground, the charge memo is vitiated.
Yes.
What other ground?
I'll come to page 20 of my grounds in an original application, valid. I've taken that.
Tell us
Yes.
what else, what
Or that
other
the
ground?
said revisiting decision of the disciplinary authority is contrary to the sanctity of the Rule 10(2), because the disciplinary authority has not exercised his wisdom in order to form an
We
opinion,
are asking
initiate
you
the,
what other ground? This we have seen 10.2. We have understood what you are saying.
and there is a delay, valid.
Delay and this 10.2.
Yes. And the third ground, valid, which I have taken on that day, preliminary ground, that writ petition is not maintainable because the prayer they are asking for to institute the disciplinary proceedings, valid.
That we have seen.
That you have. These are the three grounds, valid. And the fourth is the judgment, which is lordship. If allow me to place that back.
Yes, just
By the Disciplinary Authority, name, and Assistant Central PF Commissioner. No, sorry, Chairman CBT, who is the Corporate Authority. Page 33 of the volume 1.
Additional Central PF Commissioner.
No, no,
33
Chairman,
33
by the order, he is the Competent Authority. Assistant CPFC is not the Competent Authority.
Order in the name of the chairman, CBT.
The same authority at page 30 also issued the warning. The same authority at page 30, your lordship, kindly go, issued with the approval of the chairman CBTT. Yes.
TVC have any jurisdiction to override the decision of the disciplinary authority?
Best of my knowledge, ballot, no. The disciplinary authority is unbridled power with regard to the disciplinary procedures is concerned. Otherwise, if that would be the case, ballot, then each and every day there would be the prosecuting agency will be unsatisfied with the punishment imposed by disciplinary authority. And it might change the entire ambit of the CCS.
The CBC is constituted by a decision of the central government.
Yes, ballot.
It must have been conferred with certain powers.
Ballot.
It may have a recommendation, a power to give recommendation.
Yes.
We don't know. Therefore, we are asking you.
Because, ballot,
Because you're raising the issue of 10-2.
yes.
Now,
because
10-2, the
10 is-
CBC.
10.2 is within the ambit of the Article 309 under the subordinate legislation, ballot. So therefore, this is the statutory provision cannot be overridden by the any other prosecuting agency, ballot. Then otherwise the opinion will be diverse, not once, twice, thrice. even.
CBC is not a statutory body.
No, statutory authority, I am not saying that. I am saying,
We are asking you a question. You are telling us things which we already know.
yes, that is there. I'm only
We are
reiterating.
asking you that when the CBC is taking a view of the issue, what is the scope and ambit? Does it have any overriding power under its constitution?
To my limited knowledge, ballot, I have not gone.
That
through
will
this
not
point.
suffice. You will have to show us because you are taking a point of 10-2.
I'm taking
Now,
the-
whether 10-2 will prevail or CBC's opinion will prevail. How do we arrive at that conclusion? Unless you assist with that, just because you say 10-2 is final, we should take it as final.
because ballot 10.2 is the rules.
Now you
And-
will again say that it is statutory rule under 309.
That is my
You
submission.
need not repeat the same submission.
I stand corrected, ballot.
We
My
are
submission is within the
We
ambit
are,
of that.
but we have to see if the CBC had the authority or jurisdiction to do this or not.
No, that my learned friend will submit, ballot, in that case. They can also assist on that point, ballot.
Yes. Because it has been reopened
Because
on
that is
the,
their stand, ballot. They need
it is
to.
reopened on the stand of the CBC. Whether this was permissible or not, we have understood what you are saying. Formation of opinion was required to be independent, cannot be at the dictates of CBC. Therefore, what is the scope and ambit of the CBC direction?
I rest my case through that extent, my lord. Now, my learned friend.
You have to satisfy us. You are challenging the order. Let us see
My lord,
how it can be done on the basis of CBC report. Tell us.
CVC report, my lord, if your lordship kindly takes the CVC report, my lord, that's my lord page 47.
Not required. We will not read it 10 times. We are
there
asking
is-
you how it can be relied upon.
My lordship kindly says, my lord, what I am on is, yes, I will certainly come to that. my
No,
lord.
come to that
Yes.
first.
Yes, I'm coming to that, my lord, but why it has been reopened?
Not required. Whether it has the jurisdiction. If you say tomorrow that no, you reopen a case, will they reopen? Unless you have the jurisdiction. You, Mr. So and so, go and tell the CPFO that you reopen this case. They will reopen.
But not on one lapses. Here the
It
new
may be
lapses-
1,000 lapses.
No. Here is another.
No new
lapses, my lord.
lapses.
Another charge, not
What?
not in 2017. That's
It was already there. We have seen
no,
that.
my lord, one thing I have not, my lord,
Show us the CVC's jurisdiction. That is all. You have relied on the CVC's direction to reopen the issue.
yes.
So why have you done it? Show us how you can do it based on the CVC. Is correct. You have to tell us. It is your action. You have to justify it.
So for that aspect is concerned, my lord, CVC power, my lord, I have to see that, my lord. What is his power? Whether he has the power to reopen the case or not, my lord, against. But my lord, here, in my most respectful submission, there are other lapses which were not
That
in,
we will see.
which
only.
were not in 2017. It is in the 2021.
We are saying there may be
There my lord.
1,000 lapses.
Yes.
But
And
that
serious lapses.
very serious, the most serious lapse.
Yes.
But who is the person at whose instance it will be taken up?
Yes, that is your lordship's query. Certainly, my lord, I will bring that.
You have to tell us. That's all.
What is the CVC power?
Yes.
Whether it is a power to reopen it or
Whether
not.
they have such a
That's
power
not-
to
yes,
override the
I
service
can
rules.
bring and I can satisfy.
They
you.
are a kind of a vigilance authority over all the central government wings. We
yes.
don't know. They may be vested with such a jurisdiction that in spite of decision of a
My lord.
disciplinary authority, they can direct you or to relook or reopen. Maybe not. If not there, then how have you
Yes,
relied?
I will satisfy on that point, my lord.
Take
But
down.
apart from my lord, one respect, my lord, kindly, my lord.
After you
my
come
lord,
with
yes, my lord, I will. But my
Come-
lord, lordship kindly says,
come
my lord,
with that, we are not going to
My
waste
lord,
any
my
further
lord,
time.
one occasion, my lord, I want to
Save your energy. Save your energy. Heard
But-
learned counsel. He'll give it, you will get it.
My lord, may it be taken, my lord, parted, my lord. Heard in part. Your lordship, not the, your lordship can be heard in part. My lord, your lordship has, my lord, heard at extension, my lord. Your lordship can.
Everything is recorded, sir.
Record, but
Everything is
my lord, now
recorded.
your lordship has, my lord, heard, my lord, the,
So therefore, whatever has
time you have
transpired today
But
is
it-
already there in black and white.
yes, my lord. I want that, let it be decided. Yes, I will. Let it, oh, yes.
31st.
31st. Grateful, your lords.
31st. 31 তারিখে ঠিক আছে তো তাড়াতাড়ি বলো
হ্যাঁ 31st জুন তো 30 ঠিকই আছে 31st খালি দেখে নিন শনিবার রবিবার না তো থার্সডে 31st
Item 104. My lord, in this matter, learned advocate on record is not present. He is suffering from viral fever. I am paying for 1 week adjournment.
An adjournment is on.
105.
May please your lords.
चालीस साल पहले का बोर्ड है साहब फाइनल होने के बाद फिर फंसा दिया जाएगा ये
नो नो इस आप इस केस में है
यहाँ है
अभी बोलने का My lord, on earlier occasion, your lordship was pleased to ask me to produce certain circulars we have collected. And here the issue is, my lord, non-fixation of the, my lord, scale of pay of the petitioner. He was engaged in, my lord, 1989 and he retired in October 2018. He used to get only rupees 2,000 per month. And, my lord, this honorable court and the learned tribunal directed the authority to fix the rate of, my lord, the remuneration as per government orders. But, that your lordship was pleased to ask me earlier to produce these circulars. My lord, kindly, I have all my lord collected. My lord, may I place the, my lord, page 72? আলাদা আলাদা টাইম হয়ে গেছে
My lord, page 56 is the order passed by the, my lord, the authority, as per direction of the Honorable Court and the Tribunal, wherein, my lord, it has been held that they have, my lord, fixed my salary or remuneration as per the government order. My lord, at paragraph 3, the remuneration of rupees 4,400 PM was enhanced to rupees 2,000 PM from June 1, 2000 in terms of the Finance Department's memo number such and dated May 20, 2009 and GO number such and such of September 2007 for part-time Group D employee. Accordingly, the Technical Education and Training Department brought out its own order by number such and such. Another pertinent fact that is evident from your communication that Sri Noskor stays at this quarter and he looks after such and such. Now, my lord, your lordship on the last occasion asked me to produce the circulars of May 2009. My lord, may I hand up the,
What is it? What is it?
because by on this basis, my lord, the pay has been fixed.
It has been fixed on the basis of 7/9/2009.
That is also with me, my lord.
That's not in dispute.
But my lord, that is in dispute.
That
My
is
lord,
not the issue.
kindly see another circular.
Why you have filed a writ petition after 10 years?
the-
Application after 10 years.
That is, no, my lord, we are fighting from, my lord, since long.
You may be fighting for 25 years.
Yes.
Why you have filed the application
That
after
was-
10 years?
that
That
was-
is the query.
That was not in our knowledge in the contempt proceeding.
Let us see where you have said in the OA
Yes.
that you came to know about it within 1 year of the filing of the OA. Let us see. What is the date of knowledge in the OA? Show from the OA.
My lord, they filed a reply.
From the OA, show us.
I am, my lord, in the High Court, my lord, they filed opposition.
Show us from the OA what you have stated, why you have come after 10 years.
My lord, order was passed. My lord, Mr. Chandra, pleased to pass an order in 2022. Thereafter, in reply, they
Please
filed-
show us from
Yes,
the
I am
OA
placing, my lord.
where you have said that after 10 years you can challenge this order, although you have retired much earlier.
In 2018, I have retired.
Correct, much earlier. That's why we are saying 5 years prior to filing of the writ.
But the matter is, my lord, pending-
Challenging an order 10 years prior to filing of the OA and 5 years after retirement.
No. My
So
lord, matter-
therefore, show us what you have said in the OA regarding the delay.
Since 2008, my lord, the matter is pending.
Let it be pending for another decade. Why are you in such a hurry?
No.
This is not the way to invoke the jurisdiction.
My lord, from page 32 onwards, in the in the aforesaid circumstance, the applicant filed an application being weighed 2000, inter alia praying for consideration of the prayer for regularized service as clerk cum typist under the response 3 taking into action long continuous service. That in the said case, the learned tribunal by an order dated 2012 was pleased to
We are
direct.
not asking you to read the entire application, sir. We are asking you to show us in which paragraph you have
Paragraph
stated about delay.
33, my lord, paragraph page 33, that finding the applicant filed a contempt application. In the said contempt application, the learned tribunal by an order dated the original, then, my lord, in the contempt application, they filed the reply from there, my lord, we have learned. In the learned, my lord, of that order.
Where are you reading? We are unable to follow.
My lord, how I have collected, how I got the order, my lord, paragraph Y, page 30, that in view of the order, applicant through advocate letters are sent, registered, requested the director or the principal secretary being the responsible to look into the matter and thereby revise the scale of pay and after calculation thereof make payment. Then by an order dated September 20 is wholly, that order is wrong, and my lord, that is was filed in a reply. So from there, my lord, from their reply that was filed in the contempt proceeding on, we have got this order.
We are not asking the sequence.
Thereafter, the sage was,
We are not asking the sequence of events. We are asking you to show from the OA how it is in time.
my lord, there in a continuous process, my lord, there has been delay, and that delay part was condoned.
Where is the condonation?
My lord, kindly.
Where is your application for condonation?
That, well, kindly look at the Honorable Justice, page 65 orders,
What is that page 65?
the order of this Honorable Court.
Forget about that. Why are you referring to irrelevant things?
No, because, my lord, a sequence of
2013 fixation challenged by filing an OA in March 2023.
that's why, my lord, this order is necessary.
Not necessary.
The order,
Show us something which happened one year prior to filing of the OA.
I am placing, but kindly.
1 year. And where is, show us from the OA? We are not going to see
No,
the entire
it is
brief.
part of the way, my lord, as this, that's why the Honorable Court observed the order of July passed by the, would reveal that such and such, then, my lord, the epidemic compliance, page 66.
That's all.
Kindly please, my lord, I am
What
suffering.
is this, sir? What suffering? You retired 5 years back.
Before
The
retirement,
fixation was given 10 years back. You are suffering.
before
Now you are
retirement,
getting nothing. Where is the question of suffering?
my lord, kindly,
It was not a pensionable service. And what suffering?
my lord, kindly just page
You can't
66.
say suffering in every
Affidavit
case.
of compliance filed today would reveal that the pursuant to the order passed.
Show us from the OA.
That is the, my lord, that was part of the
Paragraph Y you have already read.
No.
At page 35. That
my
is
lord,
the only.
page 66.
Yes.
From the affidavit of compliance, paragraph second paragraph. The affidavit of compliance filed today would reveal that pursuant to the order dated September 13 passed by the court in W. such and such, the Director of Education West Bengal disposed of the claim of the petitioner by enhancing the remuneration from rupees 400 per month to per month with effect from 1st June 2000 in terms of the government order such and such. The said order was passed on September, which is within the period provided under the passed by the court. Despite having aware decision, the contempt filed. The contempt jurisdiction cannot invoke purpose of the review or can be invoked for the purpose of rehearing the matter. The moment court direct the authority to take a decision pertaining to revision such and such, the court is mainly concerned compliance order thereof. Then, under whether the decision is legal, we do not find any. However, we make it clear it is open to the petitioner, my lord, page 67 bottom. However, we make it clear that it is open to the petitioner to take appropriate steps against the said decision and on September 20 before the appropriate forum if available. So, my lord, pursuant to this liberty, my lord, we filed the OA. This order was passed, my lord, on September 16, 2022.
Yes, and where is this 20th September 13 order?
That is, my lord, that was my lord at page 56. Page 56, my lord, paragraph 3. My lord, I was appointed in 1989 rupees to 400 per month. Our all along case is that I should be, as I am continuous working, we should be regularized and pay the regular salary. That
There is no prayer for regularization before
earlier
the,
it was did.
so don't
Now
now
I
don't
have
raise
written.
the
Yes.
history.
Now,
In the OA, there is no prayer for regularization. So
Yeah.
don't say regularization. That claim you have already
because
abandoned.
I have already written.
Already abandoned,
Yes.
wrong back. So
Yes.
don't say regularization.
So, my lord, rupees 2,000 per month, my lord, is in my, my lord, considered view
Is too little.
too little.
What can be done? You have worked for that amount.
No, kindly see, my lord, kindly see the without it. My lord, kindly see the if into the
Yes. Show us.
consequent upon the revision of pay and allowances under such and such, the undersigned directed by the order of the governor has been pleased
Yes,
to.
you are covered by C.
My lord,
You have got what is due.
no, I am covered by C, but
Yes.
I am the whole-time employee throughout the.
You are not, you are a part-time employee.
I am my lord,
Part-time guard. Throughout you have been.
no, I am my lord, I am contractual.
That is your case, that you are a part-time guard,
I
night
am
guard.
contractual employee throughout the year. Then my lord, kindly see another circular of 2011.
Not required.
Dear my lord, I am entitled to get the benefit. My lord, kindly for the interest of justice, my lord,
There's nothing wrong with the tribunal's order.
I will place one paragraph. This is of September 16 to 11. My lord, paragraph II.
No, you were never, this was never applied to you. You were never given any security of tenure. This was never,
At the
this
entry
does
point
not,
basic pay.
this does not concern you, sir. This is for a different.
At the entry point basic pay will be 6,600.
That security of tenure you never prayed for, it was never granted. So that cannot be relied upon.
My lord, that is our all along. That
Sorry,
is
nothing can be done. Yes, take down. Hard learned counsel.
106.
106, my lord, I am for the petitioner, my lord. The union was supposed to serve an affidavit of opposition. They have served me today itself, my lord. So, my lord, I will not file
To
any.
file a reply.
I will not file any reply, my lord. Kindly gives me a couple of days time to just go through. My lord, kindly keeps it on Friday, my lord. It's possible. Because they have relied on certain master circulars and number of other documents.
An opposition filed today.
I'm grateful, man.
One zero seven.
I am challenging the order by the Honorable Tribunal in respect of voluntary return in service. And I have, on last occasion, I have pointed out regarding the jurisdiction. Petitioners was working at Ranchi and cause of action Ranchi. Second point, my lord, the resettle of representation in respect of the VR application suffers mental problem of the applicant. So I am asking myself, if any employee suffers mental problems, can he join the government service? And first 29th November 2021, the respondent made an application before the authority for voluntary retirement. Kindly see the resettle of the representation. Page, my lord, 34. Prayer for voluntary retirement from government service, thereby giving 3 months notice for the same under Rule 48A of the CCS pension rules from the date of submission of the application. Paragraph 7. I have been affected with several mental disturbance, mental infirmity, and deteriorating health conditions since the said demise of my mother this year, and I am also in the state of turbulence due to serious problem in my family which I cannot ignore at the point of time and needs urgent attention and which needs to be fixed immediately. Thus, presently it has become very difficult for me to continue in the service of accounts officer in the IP and TAFS Group B cadre as the service demands I degree of alertness and updation of rules, regulations, adhering to the latest policies and guidelines and latest information. Hence, I would not be able to continue any further service. I have no option but to seek voluntary retirement on 1st March 2022 to enable me to attend to my health and urgent family compulsions and obligations. On the basis of that, my lord, the office order has been issued and the name of the respondent have been struck off, my lord, on the page 36, 28th February 2022. On 23rd February 2022, my lord, before that, respondents made an application on 14th February, again for continuation my voluntary retirement. Cancellation of request or in respect of voluntary retirement. Page 37 and 37A type copy.
And on the basis of that, committee was formed, and committee has decided that person respondents retirement will effective from 1st March 2022. And the judgment passed by the tribunal reflects that the Ahmed, I brought this judgment, that this judgment has no manner of application in this respect. This fact is totally different. I have handed over to your lordships the judgment, which have cited by the Honorable Tribunal. Yes. Jurisdiction, my lord, the arose at Ranchi, and at the any point of time, at any moment, my lord, the jurisdiction can be applicable, my lord, in view of the Supreme Court judgment, Kanwa Singh's signing. On the last occasion, your lordship asked me. That is, I have handed over to that. Paragraph 13, 11. Paragraph 13 is the relevant portion, my lord, at any stage. and Honorable Tribunal has reflected the judgment I have handed over to your lordships. That is the facts of this case. This case, has no manner in application in this present case, my lord.
Tribunal has
That case,
distinguished.
this case, my lord, that tendered, my lord, the application for voluntary retirement. On next day, my lord, he withdrew this application for voluntary retirement for continuing service. In this case, my lord, before 8 days, he made an application for withdrawal. Again, my lord, on page 71, again he made the application for continuation of process on 28th February, page 71. 2 times. And respondents have admitted the mental disturbance. I am asking myself if any employee, government employee, suffers mental agony or mental disturbance, my lord, government can join.
But he has only referred
the
to
responsible
in his OA, he has only referred to one withdrawal. That is of 23 to 22. In his OA, he has only stated about this A3.
Page 71. Kindly see R6. 28 February 2022.
You have placed this before the tribunal.
Yes, before the tribunal.
You have filed this.
I have filed this application before this tribunal. My learned friends filed this application way regarding the action passed by the authority. Even though they are no.
On response of the application, it has replied.
Yes, reply. My learned friend has given the reply. In my reply, my lord, before the original application, before the tribunal, in respect of A. In my reply,
The first application.
Start from page 46, annexed P2.
What is the first application for withdrawal?
First application, my lord, kindly see page
37.
34. Page 34. We application.
You are asking where is the first application for withdrawal? You are showing page 34.
First application for withdrawal. Yes, my lord.
Page 70, my lord. Page 70R.
Page?
Page 70.
37. Page 37, 37A.
Yes.
Page 37.
He is saying 70. What is 70?
Same.
Yes, that is the same.
Yes.
23rd Feb. Page 37 is the first application.
Yes. Request for cancellation of voluntary retirement stated on 1st March 2022.
This was received by you on which date?
23rd February by mail, my lord. My mail to the member of finance headquarters.
No. Where have you said what is the date of receipt of this application? Show us.
28 February.
Where have you said that?
Reply, page 70.
Page?
70. Please stamp.
Where have you said when did you receive this application? In your reply, what have you said? Forget about stamp. Yes.
Relevant. Now page 9. February 2022. My lord.
By which order the VRS has been allowed?
That is allowed, my lord, the order passed by the committee, from a committee, my lord, page 60. And this committee was formed by the finance department. 48A regulation rules 3A and 3 capital A B. This is applicable in this case, my lord. I have annexed this circular page, my lord, the 70 page 372 page, and relevant portion, my lord, the page 73. I have annexed my original WP city applications, my lord. Rules.
Which provision you are referring to?
But, my lord, I have annexed this rules, my lord, page 72, annexed at P1 in my application, my lord. 48, relevant 48A, my lord, 72, it starts folding this. And relevant portion, my lord, is 73. 48A, subsection 3, capital A, B. On receipt of a request under clause A, the appointing authority subject to the option of subrule 2 may consider such request for curtailment of the period of notice of 3 months as merits, and it by that the curtailment of the period of notice. Yeah, what are the point I'm for 8%? Let's go to the gym.
Seat in their office on. Said so. From the earlier page, last page. Thank you, Tom. See you, Tom. They say by the time it's communicates, you are accepting it. That acceptance is with your you have to find it. It says ordinarily.
So on 28th, it was received by you. That is not in dispute. Two things are not disputed. You received the application on 28/2.
Yes.
It is also not disputed that the VRS was to take effect on 1/3. Next day.
Yes. Yes.
There is no dispute regarding this.
Twofold submission. The Honorable Tribunal has no jurisdiction to interfere this order, passed by this order, my lord. And second point, the Honorable Tribunal has reflected the judgment. Fajjuddin's case, my lord, Fajjuddin's case is altogether different. It has no manner of application in this instance.
No, let us see it without
Yes.
the judgment. Let us see it without the judgment.
Yes.
Forget the judgment.
That first time, my lord, respondents have paid before the authority on 29th. And second time, my lord, the 20th February. 2 times. Continue. One time withdrawal, then again to continue my retirement, voluntary retirement. So that person is not mentally fit and admitted in his representation that heavy workload, I am not enabled to perform my duty in the reflection of
So
this
you have
representation.
considered this. You have considered this in your order for accepting his VRS.
Yes, but already.
Where is show from the order where you
My
have
order sheet, my lord, kindly see page. Kindly see page. I have cited out page, my lord, 36.
You have
My
con-
application office order.
you
on
have
20th
considered that he is filing repeated applications.
Yes. But on the basis of that 29/11/2021, that is the office order. Notice for voluntary retirement from government service case of Sri Partho Bhadro AO office PO Ranchi. Member Finance is pleased to accept the notice given by the under mentioned Assistant Accounts Officer.
You are only interested in speaking, or you want to reply to something we are
Reply my page 16, page 60, my lord. Kindly see. Page 60.
You have just now said
Yes.
that he is not in his proper sense. He is giving application of all kind. Therefore, he is not fit to continue in service. This is your stand. Where have you said this in the order accepting his VRS? Have you said this in your order accepting the VRS? That this is the consideration. Just see this page, that page. We are asking you a query. Show us from the order.
He is not fit for this job. Representation has mentioned, but specific, my lord, the word has not mentioned. Page 60, kindly see the Sri Partho Bhadro AO.
Page 60, we don't know what.
Yes, my lord, I am pointing out. Ranchi had preferred an application placed in file dated 29th November.
What is at page 60?
Page 60, my lord, the committee was formed by the finance department regarding the hearing in respect of the voluntary retirement. In my original application, kindly see. And the representation 29th November 2021 has mentioned. Not in detail, that reflection in the representation.
We think right now whatever she said. Page 60.
Yes, ma'am. That is the PUE request for voluntary retirement dated 16 February 2022, served by, and this was communicated by the petitioner. No, not only. Page 4, 68, sorry, my lord. Page 68.
You don't bother to read the brief
sorry,
before
sorry.
coming to the court. That is the
Sorry.
biggest problem.
Sorry.
Everything
Sorry,
you have
ma'am.
to ask her and then you have to reply.
Sorry.
You have not bothered to go through the brief.
No.
Even
My lord,
one.
sorry, I tender my apology.
This is the way to appear before a division.
Yes.
Very nice.
My page is 68. My page 68. Sorry.
Everything we have to ask you 10 times.
Yes. Sorry, my lord. Page 68. এই যে করোনা পেজগুলো ঠিক করো না কিছু ক্লার্কের উপর ভরসা করো তুমি পিটিশন সরি my lord, page 68 কেন যে এসব কাজ করো কি ক্লার্ককে কেন দাও নিজেগুলো তো দেখতে পারো পেজগুলো ঠিক আছে কি
What is this you are showing us?
my lord, the committee was formed by the finance department on the page 69. Next page, my lord. This is the ACAO director, DDG, senior DDG member. And that was done by the Ranchi. In case of Ranchi. পেজগুলো সবসময় দেখে নেবে ঠিক করবে এত রিল্যাক্টেড হলে হবে কোর্টের কাজ এখানে 60 আছে কি কেটেছো কি করেছো কি চলে যাচ্ছে আমার কাছে 64 করে যাচ্ছে কি যে করোনা পেজের পেজ কেটে গেছে অর্ধেক পড়ে গেছে ইয়ে হয়ে গেছে
Yes, how could you have filed the OA in Ranchi, in Calcutta?
My lord, OA.
Yes.
My lord, I came back from Ranchi after the effecting of the VR, signing of the final charge report. I came back to Kolkata to my home, and then I filed the OA. I was not at Ranchi.
So after retirement, you have filed.
After 1st March 2022, I have filed.
After accepting the retirement.
After.
So once you have accepted, then how you can be permitted to again turn back? That charge report on 1st March you have accepted, you have relinquished. You could have raised an objection on that day that no, I have already given application for withdrawing. Why you have not considered the withdrawing application? You have not done
My
it.
lord, I have requested my director on the next day also that please restore my services.
How can you?
That was done on a compelling situations.
That's not the point. The point is you gave an application. Maybe compelling, maybe very bad situation, very extreme circumstance, hardship, maybe. We don't know. You may be true, you may be wrong. We don't know. That's not the scope of the proceeding. 2 times you asked for withdrawing, 2 times you said you go ahead. Finally, they went ahead. They gave you the VRS. You went and relinquished the charge. There is a specific order. You have signed it that yes, I am going on 1st March. Why did you go? You could have stayed. You should have said that no. Why you are not considering my application for withdrawal? On that day, there was no compulsion.
My lord, after issuing of my VR orders.
Come to your 1st March report. Where is the 1st March report? Page 38. This is signed by you. You have accepted it.
My lord, I came to know from the office that after VRS is accepted, VR is accepted, there is no scope for a government employee to continue in service. But they have affected my VR on a wrong rule. I had not applied on that rule. I had applied on 48A, and they have ordered on a separate rule, 48(1)A, that demands 30 years of service. Whereas I have served my department for 26 years.
27 years.
27 around.
Yes. So you know all the rules. Everything you know.
I know these two rules.
So when you know everything, why did you accept the charge report? That is what we are asking you. You appear to be knowing everything. Your application for VRS is quoting all the rules. In every communication, you are referring to the rules. So you know, it is apparent that you are a very literate person and you are a well-informed person, knowing everything. Then why did you accept?
Another thing, the rule was changed. The CCS pension rules 1972 was replaced by CCS pension rules 2021 on 20th December.
December?
20th December 2021.
Yes.
In the Gazette, my lord, I have filed a CAN application.
So if it was changed, what was the change?
Change was rule that my rule would have been rule 43, and what for 20 years of service, and for
No, you have made application under 48A.
Because I had made an application on 29 November. At
Correct.
that point of time, that rule was relevant.
Very well.
But on 20th December 2021, that rule was subsequently changed.
All right.
By a Gazette notification.
So therefore, we are saying, what is the change? Does it say that all the pending application will now have to be considered under the new rule?
And they have issued a separate rule, my lord. They have issued 30 years of, on the strength of 30 years of service, they have issued 48(1)A.
You have made application under 48A.
48A. And in the VR memo, my lord, you...
what is the difference? Show us the difference. Where is the difference in the rule? How it affects your case? There may be a change. How does it affect your case? Seems you are very well informed. You know that after retirement you can file it from Calcutta. So you have filed it after retirement from Calcutta. You know the provision under which application has to be made. You know the date of amendment. So what is the change? Tell us. That's why we are asking.
To know afterwards, after making RTA.
What is the change? Tell us. How does it affect your claim? Please show us what is the change. It has been changed. You have submitted. Every change is not relevant unless it affects your claim. So what is the effect? Show us.
First, I forwarded my withdrawal application on the 23rd.
See, once you make a submission, you have to take it to the end. You can't make one submission and jump to the other case. Just now you said there is a change. They were required to consider it under the fresh So why? Where is that provision? Show us.
Provision I have.
Then you will go to the next point.
I have filed in the RTI application.
RTI? Why RTI? The Gazette notification is for everyone. Why do you have to file RTI for Gazette notification?
This is my lord, and I have.
What are you giving us? What are you giving us? First, tell us what are you giving us?
I am giving the Gazette notification.
Giving the
Gazette notification.
The fresh rule.
Fresh rule. And I am also filing one supplementary affidavit, my lord.
For what?
For all the sufferings the department has.
Sorry, nothing beyond the tribunal's order. Whatever is there in the tribunal, only that much we will consider. You keep that. You give the rule. You can't enlarge the scope of the proceeding in the higher court. You have to confine your case to the pleading.
And they had also effected a transfer memo, my lord. Huh? Arekta? The CAN application, my lord, it is there in page number 28.
Then why are you giving this? Why this can has been filed? Page 28.
Yes, my lord.
It's not at page 28.
Annexure P7. Oh, that is at this one. This, my lord, kindly please peruse my supplementary affidavit. Here it is given.
20th December 21. Keep it. It is here. Page is 33. Yes. 30? No, 50th. Page 50. So what is the change? We have it. What is the relevant change? Show us from this notification.
It is, my lord, it is rule 43 of CCS pension rules 2021.
Yes. Yes, so now it has become 20 years. Rule 43 has made the period for 20 years. And what was the earlier period under the earlier rule?
Earlier rule, it was 48A. 48 capital A.
How many years?
20 years.
Same. So what is the difference?
But difference is that in the final memo, the department has issued rule 48(1)A. That is relevant for 30 years of service.
48(1)A.
Yes, my lord. At page number.
So are you being deprived of your pension benefits? You are not.
I have not applied for pensionary benefits.
No, no. Do you? If they say 30 years, will you be deprived of pension benefits?
I was affected a wrong rule.
See, a wrong rule, unless it affects you, it is irrelevant. They may say anything, but if the effect is, there is no adverse effect, then that is meaningless. Therefore, we are asking you how it affects you. Instead of 43, they have said 48A. You are saying it is wrong. They may say it is right because your application was made when 48A was very much in vogue. It was made under that rule, so we have considered it under that rule. You may say no, they are required to say 43, but what is the effect? How it affects you, that we are asking you.
My lord, I wanted to continue my service. And
that is not the point. Then the rule quoting of wrong rule is not of any relevance. That you want to continue, that we have seen. So there is no effect by the change of rule. But you want to continue. You have given application for withdrawal. This is your case.
Yes. On the 20, I have tendered my application for withdrawal. And under compelling circumstances, when I was told that I have no scope to continue in government service, I made further representation. And on the next day, kindly peruse this, my lord. I have written everything.
No,
Kind-
sorry, only the tribunal records, nothing beyond the tribunal records. We will not accept. The court is not required to and is not expected to go anything beyond the OA records. Because the tribunal's order, we are seeing whether it is correct or incorrect. That has to be decided on the basis of pleading which was there before the tribunal. Something which was not before the tribunal, how it can consider?
My lord, I requested Director Rachi to restore my government services.
That we know. Then why did you give the charge? That is why we are asking you.
That came, my lord, to relieve me.
Should not have given the charge.
And he asked me to meet the authorities, to approach the authorities at Delhi. So I went to Delhi and met senior DDG PAF. He told in his DOP Department of Post headquarters at Dak Bhavan, he told that your service, we are not accepting your voluntary retirement, and we will restore your services. You go back to home. We will issue memo shortly. That's why I waited for 5 months on his assurance.
Since he has accepted. Where is the charge report of 1st March? Charge report. Page 36.
Page 38.
8. So after 1st March, when did you write to them?
I wrote a letter on 15th August. Because, my lord, I waited for 5 months on the assurance of the Senior Deputy Director General of Delhi, of our department. He assured me your services will be restored, you go back home. But he did not issue any memo for restoration of my services. I have written all the truth in my supplementary affidavit.
Nothing, sir. We will not accept anything now.
Yes.
There is no such application for the. It says that BRS notice was withdrawn. 15 minutes. Presentation withdraw. Where is the consideration of his charge report? Where is the consideration of his charge? Move. One question. All right, we'll come back. Just wait.
Item 107.
Yes, my lord, in this matter. So my learned,
But we shall not be considering this. We are keeping it on record. This is extraneous material. This is not required to be considered. That's all.
a subsequent notification is not application in this manner. That is this, my lord, my learned friend has shown this notification. That notice that at that relevant point of time, 48A was prevailing. New act, my lord, 43. It is not applicable in this case, my lord.
What difference does it make?
Differs nothing but rule 43 or 48. That is the only difference of 48A or
What is CAB?
Order maybe CAB. Develop.
Item number 2.
Tomorrow you can have.
এর আগে তো কোনো মানে হিয়ারিং হয়নি, इसमें हियरिंग नहीं हुई। हाँ ग्रुप, इसमें कैप्टन की जगह ग्रुप कैप्टन होगा। हाँ उसका नहीं आगे चेहरा तो देखे मेरा। My lord, we are challenging the order dated 5th August 2024 of the Armed Forces Tribunal, my lord. Petitioner is the Air Force, my lord. In this case, my lord, the respondent was enrolled in the year 1988, and in the on 30th June 2022, he was discharged at his own request, my lord. 30th June 2020.
30th June?
2020. He was discharged at his own request. He was not discharged on medical ground.
And he was commissioned in 88.
88. In point order, my lord, Honorable FT Tribunal consider the judgment of the Dharmveer Singh case, which is based on the rules and regulation of the army, my lord, which is not applicable in the Air Force, my lord.
Forget about Dharmveer Singh. Tell us why otherwise he should not get.
My lord, in 2008, he was the respondent was the chain smoker and detected heart disease, my lord. Kindly see, my lord, specialist report, my lord, page 95.
What consideration has the released medical board accorded to the several injuries sustained while ejecting from the aircraft, crashing aircraft? Where is the consideration in the released medical board? Show us.
For that, my lord, we are not disputing for that, my lord.
It's not a question of disputing. Where has the released medical board taken this fact into consideration?
That was
He
not
ejected
considered.
from a crashing aircraft.
Crashing
He
aircraft.
sustained multiple injuries. There were screws put in his legs. He suffered injury in his spine. Where has the released medical board taken into consideration?
That was not considered.
Then
That's
why we said forget about Dharmveer Singh. What kind of consideration? These people who are putting their lives at stake. This is how you are treating them.
Kindly see the prayer of the respondent, my lord.
Forget about prayer, sir. These are facts, not in dispute.
Not in dispute, my lord.
Then,
for this, my lord, resurvey medical board, there was a direction for resurvey medical board.
Resurvey?
Resurvey medical board.
Who directed?
Honorable FT, my lord.
So did you do that? You have challenged the order. You have no litigation policy. You will challenge any order.
No, we are challenging second disease, my lord.
So we are saying forget about the second disease. This severe injury that he has sustained, will he be entitled to disability element of disability pension less than 70%?
No, he is getting, my lord, 75%.
That you are challenging.
No. For the diabetes, he's getting, my lord. We are not challenging.
What are you challenging then?
My lord, kindly see the prayer, my lord.
No, what is your, why are you aggrieved by the order?
Contrary, page 70, my lord, kindly see.
Don't show us the page. What is, how is, where is the shoe pinching? We want to know. What is wrong with the order?
Part 1, there is a disease which was pertinent.
Kindly see for a moment, my lord.
What
page
is
70.
it? Page?
Page 70.
70?
70.
What are you referring to? The order of the FT?
No, my lord. Part of the part 6 of the release medical board.
We are asking you, what are you aggrieved by from the tribunal's order? You have filed a writ petition.
Because
they have asked you to do a resurvey.
Because the said disease is neither aggravatable nor
disease.
Heart disease, my lord.
That was not.
Maybe. So after the review board, what will happen?
For this, there was no direction for review medical board, my lord. For this
Now
disease.
you said that there is a direction for
the spine injury, there was a direction. Kindly see, my lord, for a moment, my lord, kindly see the.
We'll see that as a result of the heart ailment, what is the benefit that he is getting?
My lord, he was treated, my lord. FT has been given 30%, my lord.
30% disability element of disability pension.
Yes, my lord.
Now, if we exclude that, and after review medical board, this disease is taken into consideration, will he get anything less than 30?
No, he's already getting 75%. No, in diabetes.
You tell us, sir, why are you asking him? You have challenged the order. We are asking you basic things.
No, just a minute.
We are saying, why are you here? Is there a policy of litigation or you just file a writ
No, my
petition
lord.
in every person who gets a disability element? Because every day we are seeing all the cases, you file a writ petition. Wherever the armed force tribunal gives a benefit to any personnel.
Page 9 or 3 of it.
Contrary. 78. Page 79, my lord. Para E, my lord. Accordingly, the applicant has already been granted disability element of pension at the rate of 50%. He is getting 50%, my lord.
For what?
For diabetes.
So for diabetes, he is getting 50.
50.
And for this injury, how much do you expect he will get?
If not injury, heart disease, my lord.
0.
Sir, for this several multiple injuries sustained while ejecting from a crashing aircraft, what do you expect he will get? You are doing these cases every day, therefore we are asking you. By now we have developed some idea.
My lord, that is depends upon the report.
He will get much more than what he is getting right now. Therefore we are asking you, what have you challenged the order for?
Because the respondent paying for reserve by medical board and AFT granted the interim relief, my lord.
Interim relief?
Yes, my lord.
This is not a final order.
No, final order, my lord. Subject to correction, my lord. Kindly see their prayer, my lord. What is their prayer, my lord?
What do you mean interim relief?
Sorry, final order, my lord. Disposed of. Page 41, my lord. Relief sought by the respondent.
The respondent is here.
Respondent.
What do you expect after this injury is taken into consideration?
At least 75% or more, my lord.
From the experience we have, we think he will get at least 75%. So let them do a resurvey.
And in resurvey medical board, if the matter remand back before the resurvey medical board, we have no objection.
He will also have no objection. You have ignored his major ailment. You are running after a cardiac disease, CAD. Nobody can dispute that it is attributable to his service.
In the same, my lord, I am relying upon one division in judgment of Madras High Court, my lord.
Yes, what does it say? Show us.
Cardiac.
What does it say about someone who jumps out of a crashing aircraft?
No. Only say
Jets.
cardiac heart disease, my lord.
Yes, show us. It has said anything that a CAD is not to be considered as attributable. Where is that finding? You want us to read the entire order? Can you point it out?
Paragraph number. Internal page 15.
First of all,
On the page full.
In every case, you file a writ merely by saying Dharamveer Singh has been followed.
Page 19. Internal page 19.
page 20, para 25, my lord. Disease is the same, my lord.
We don't find any such finding that CAD cannot be attributed to service. From para 25, what you are pointing out, we don't find.
20, internal page 19, my lord. Para 25.
Yes. Where does it say that CAD cannot be attributed to service? It says in this case, does not reveal any exceptional stress. It does not say that CAD cannot be attributable to a service. It is with reference to that individual.
Lifestyle disease था, chain smoker था.
But my lord, in this case, the respondent's lifestyle, my lord, he was the chain smoker.
That you have said, but just now you said Madras High Court has held that CAD cannot be treated as.
Page 97, my lord.
It's not the case.
History was given, my lord.
You want to contest the claim for CAD also?
My lord, in regard to the claim of the CAD, my lord, there are some elements of contest, my lord.
All right, let's see then.
My lord,
What according to you they have overlooked?
I will take your lordship to the release medical board, my lord.
Yes, page.
Page 72, my lord. 72 and 73, my lord. There was a manipulation in my back in the release medical board, my lord. Page 73 was the actual board that took place in my presence, bearing my signature at the top right corner.
Yes, we see it.
Yes. That was subsequently cut, my lord, the strikeout sign, my lord. Thereafter, my lord, behind my back, page 72. The same page.
Oh, the page has been crossed.
No, my lord, not the page, my lord. This is a copy of the true copy of the release medical board, my lord.
But
My lord,
signature it is not crossed out.
no, signature is not crossed out. And my lord, may kindly take the previous page, my lord, page 72.
Two.
Earlier page, my lord, previous page.
Yes.
That is the same page, my lord.
Yes.
My signature is not there, my lord. This is the same page that has been produced by the respondent for relying on giving me lesser percentage, my lord. Here,
What is the difference between 72 and 70?
The difference is that, my lord, in the actual page, page 73, the composite assessment is 50%. Now, my lord, 50% will automatically be rounded off to 75.
75. On there, they have done it at 40.
They have done it 40% behind my back.
Both are of the same date.
Same, no, my lord, they are not supposed to be of the same date because.
No, we are asking you as a matter of fact.
No, my lord, I am totally unaware about how 72 page came out because it did not happen.
So you have not annexed this in your OA.
My lord, when this OA, a copy of the OA came, when the copy of this release medical board came, I found both these two pages annexed. Where, my lord, this page, page 72, this manipulation took behind my back, my lord.
No,
because
but that means you are having this document from the date of RMB.
No, man. But the rule is that when a rejection letter comes to me, the initial rejection letter, that accompanies an approved copy of the release medical board. When that came, my lord, I found this page.
But this all, oh, this stuff.
Whereas, my lord, may kindly come to page 83, my lord, 82, my lord. What the respondents have submitted before the AFT, my lord.
Appears to be of a different date because even the members are different.
Yes, my lord. Yes, my lord. That particular page has been changed, reducing my percentage. Whereas, my lord, the respondents in their reply before the learned tribunal, which is available at page 82, my lord, the relevant pages starts from page 82.
Very short reply.
Short reply, my lord, but page 82 may kindly come, my lord. Just before the tabular part, my lord. His release medical board, my lord, got it, my lord? Page 82.
Yes.
May I read out, my lord? The last paragraph. His release medical board, not solely on medical ground, was held at 6th Wing Air Force by the FMSF 16, dated 17th February 2020, and he was found fit to be released in composite low medical category A4, G4 permanent for the following disabilities. This also says 30%, that is the modified, my lord. Subsequent page, my lord, page 6, internal page 6. His release medical board was approved by wing commander such and such.
No,
of
this
Air Force.
30% is same in both at page 72 and 73. There is no difference.
No, my lord. 30% for the heart disease is different, my lord. It was 40% reduced to 30%, my lord. For which, my lord, the composite assessment got reduced.
No, percentage of disablement in 72 and percentage of disablement in 73 is one and the same.
Yes, my lord. I'm so sorry, my lord. The composite assessment is different.
Composite assessment.
Composite assessment.
Yes.
My lord,
So instead of 50, they have said 40.
40, my lord. 40, my lord. Now, my lord, what is the submission of the respondent in their reply, my lord? Page 83, starting line, my lord. His RMB, that is Release Medical Board, was approached by Wing Commander such and such of Air Headquarters RKP dated 26 November 2020. RMB had calculated composite assessment at the rate of 40%. However, correct composite assessment is 51%, rounded up to 50%. Madam.
So you are saying why they have ignored page 73?
My lord. Page 73, that is the composite assessment, 50% had to be calculated.
You have raised this issue in your OA.
My lord, it is there in my OA that has been replied by my learned friend.
This is with respect to which condition? The diabetes?
But composite assessment is in regard to both
taken together.
Yes, sir.
So if the CAD is excluded, then it will vary.
It will vary, my lord. It will vary, my lord.
So that is one aspect of the matter. They are saying that your reckless lifestyle has led to this CAD. That is the substance of their case, because you were a chain smoker. So that is, according to them, cannot be attributed to service.
My lord will kindly appreciate from the medical jurisprudence, my lord, CAD, coronary artery disease, is not caused only because of smoking or anything like that, my lord. It is a result of several things, my lord, including stress and strain, my lord. And my lord, undoubtedly, I was a fighter pilot. I had ejected, my lord. And thereafter, I have been given my job in training aircrafts, my lord, which are far more dangerous than regular aircrafts, my lord. Leading to which, my lord, I have placed my case that leading to this inherent stress and strain, this part of the disease has developed, my lord. Now, that was not considered, my lord, only because that has developed in peace station.
Where have they said that?
My lord. Well, at page 70, my lord, disease is page 70, my lord, the Release Medical Board, my lord. My lord, is got his, my lord?
Yes.
CAD, my lord, details justification. Disease is not attributable and not aggravated by service as per approved Charter of Duties dated 25th October 2008. That is on 25th October 2008. For
you are reading from
my
page
lord, I am reading
70?
from page 70, my lord, 7070. That is part of the Release Medical Board, internal page 7.
Opinion.
Opinion, my lord.
Second half of the page.
My lord, second half of the page. My lord, in regard to CAD, the details justification, why it has been held to be neither attributable to nor aggravated. But the reason says, disease is not attributable and not aggravated by service as per approved Charter of Duties dated 25th October 2008, which means, my lord, the only thing that has been taken into consideration for determining whether this disease is attributable to or aggravated by service is my service that I had undertaken in the last 14 days only, my lord, starting from 25th October 2008. Only 14 days. That is what the respondents desired to say, my lord, is that a person will develop CAD only in the last 14 days. That depends, my lord.
And this RMB is being held on which date?
Well, at the date of the RMB is there in the first page itself, my lord. I shall assist, my lord. 17th February 2020. Page 58, my lord.
So therefore, it is a long period. 12 years.
In 2008, they are telling in 2008, last 14 days charter of duty prior to the onset of the disease, prior to the revealing of the disease, when it was revealed, just 14 days prior to that, whatever service I have done, that was only taken into consideration for determining.
Entire service report.
And 2008, my lord, I was posted in field peace 31st March to 13th February 2011. That your lordship will get at page 59, my lord.
No, they are required to specify the details in Appendix A. Where is Appendix A?
Well, Appendix A. Appendix A to the release medical board, my lord.
Yes, see at the bottom a detailed justification regarding the board's recommendations on the entitlement of each disease must be provided sequentially, especially in NANA cases as per enclosed Appendix A. So they have considered, see clause 3 of the next page. Initial medical board, release medical board, posting profile, job profile, everything, medical case, injury report, and 14 days charter of duty. So it's not only based on 14 days charter.
Well, the justification says only 14 days charter of duty, my lord.
Yes, because it is mentioned that there is a detail in the appendix, and that appendix is given. You have it, you have annexed it. It is in the next page.
Here, page 71.
These were annexed, my lord, but whether they were considered or not considered, that remains in shadow, my lord.
According to us, it is as clear as daylight.
My lord,
They say that we are giving it on a separate appendix, and they have given it.
my lord.
Now
Right,
that,
no doubt, my lord.
there is no question of doubting that they have considered it. Whether that consideration is correct or incorrect is a separate issue. And they have considered a lot of things. A, B, C, D, E, F, G, H, I.
But this stress and strain, my lord, that the respondent.
That is why they say, see posting profile, job profile, everything at C and D.
What has been overlooked, my lord, is that, my lord, may kindly come to the posting profile, page 59, my lord. Merely because a person was posted in field, your lordship is very well acquainted, my lord. It cannot be taken into consideration that the person was not suffering from any stress.
That's
or
not what they are saying.
Stressful.
You are putting something in their mouth which they are not saying. That is the point. They are not said so that just because you are posted in a peace area, therefore it is not attributed. That's not their case. Their case is the RMB's opinion of the board is recorded, and the detailed justification for the opinion is given by an appendix. So that is, and it's not in dispute that you were a chain smoker. That aspect has not been denied or disputed by you. So therefore,
Well, let me kindly come to the impugned order, page 6, what the tribunal has relied on for granting disability element, my lord, in regard to the heart disease, my lord. Paragraph 15, my lord. Internal paragraph 15, my lord, page 6 of the impugned order, my lord. May I read out, my lord? Now coming to the first question, learned counsel representing the applicant has strenuously argued that at the time of his enrollment in the Air Force, the applicant was not suffering from any disease of this nature, nor did sustain any disability, and rather was found in medical category A1G1. On the other hand, while posted in 409 AFS at Hyderabad on 31st of March 2008, due to stress and strain of service, he felt chest pain and was admitted to hospital on 3rd of October 2008 and diagnosed on 3rd of November 2008. He was diagnosed to be suffering from CID such and such, my lord. As the blockage in the artery was diagnosed to be more than 70%, he had to be operated upon by inserting stents. He was placed in LMC A2G2. It is thus seen that the applicant has suffered the disability after having served the Air Force for about 20 years, my lord.
So which rule is governing the assessment? The assessment is governed by which rule?
My lord, it has to be by the entitlement rules, my lord.
Of the later one?
2008, my lord.
8 one. So 2008 one, which relevant provision?
The onus will lie upon the respondents.
That's why we are saying, where is the provision?
My lord, I suppose it is paragraph 9, my lord, of the new rules, and
You have a
7
copy?
of the previous.
Do you have a copy?
But I'm not having the copy right now. It is onus of proof is, my lord, 7. Ordinarily, the claimant will not be called upon to prove the condition of his entitlement. However, while the claim is preferred after 15 years of discharge, retirement, invalidment, or release, by which time the service document of the claimants are destroyed after the prescribed retention period, the onus to prove the entitlement will lie on the claimant. It is 7, my lord, of 2008 rules. My lord.
No. You did not seek a direction for consideration of that injury sustained.
My lord, the diagnosis, my lord, was done.
Huh?
No doubt, my lord, the diagnosis was not done. Diagnosis was done in 2008, my lord, taking into consideration basically the 14 days charter of duty, which is already annexed, my lord. Apart from that, my lord, nothing has been
Saying
taken.
the same thing. We are asking you something else.
My lord,
Now
my
you
lord,
are stuck on the same thing.
My lord, I did not catch what your lordship was asking.
We are saying, did you pray before the tribunal for reassessment regarding this injury?
Yes.
Where is that?
Well, in the way, my lord. They are in the original application, my lord. Page 41, my lord. Page 41, my lord. Prayer number 2. The respondent's consent be directed to hold an appropriate medical board.
So has this direction been issued by the tribunal?
Yes, my lord.
Only for one disease.
I have prayed for one disease only, my lord. For the other, my lord, the first prayer, my lord, I have prayed that the applicant's disability, namely CAD, be declared aggravated by Air Force service, my lord. aggravated.
Where is the rule? Let us see the rule. Whether it says only aggravated or attributable and aggravated both.
My lord, what the respondents have done, my lord.
What's the rule, sir?
My lord, I am having the soft copy, my lord. The hard copy must be with your lordship's, my lord. It was taken into consideration several times, my lord, in other cases.
Maybe you are right.
Entitlement rules.
Page 14 of the has the chart showing different.
No, let us have a look at it.
Both 52 and
It was given in a spiral binding.
page 14. I have to
Page
page 14.
1/4.
of the rectification.
Rule 11 has not been quoted, my lord.
No, we are not looking at the quotation. We want to see the rule. You will say not quoted and wrongly quoted. Why should we? Rule 7.
My lord, rule 7, my lord.
This is pension rate. No, we are not able to find the rule. This is pension rate. You come with 2 printouts. We'll see it.
My lord, sir, come.
You know,
We have two. Maybe it is that one. Oh, entitlement rules for casualty. 2010, 18/1/2010.
18th is the covering forwarding letter, my lord. On the next page, entitlement rules for casualty penalty of
Yes,
147 to 2008, my lord.
Yes. 11.
My lord, 11, my lord. 11 is regard to aggravation, my lord.
Two conditions must be satisfied. And similar are also rule 10 in respect of disease, my lord.
Yes.
Two conditions must be satisfied.
What is the condition?
First, the disease has arisen during the period of military service. It is not disputed. Second one is, my lord, important is, my lord, B, that the disease has been caused by the conditions of employment in military service.
And who has to establish this?
My lord, kindly again see, my lord, rule 11, my lord. Field operation high altitude, and he was posted in peace area.
Who has to establish this? The second condition in clause 10, who has to establish this? Is he required to establish this?
No, my lord, burden of proof lies upon
you, yes.
Kindly see page 59, my lord, once again. There is a tabular, my lord, in respect of his placement. Injury.
And it is payable only on being attributable or only on aggravation also it
Both,
can.
my
Where is this?
lord. Either attributable or
Where
aggregate.
is it?
Pension regulation, my lord.
Which clause?
It is, my lord. 37, my lord. Pension regulations for the Air Force, Part 1, Regulation 37A, my lord.
Air
Disability-
Force.
Yes, my lord.
There is also one copy, my lord. I have seen, my lord.
But I am having another copy. The page numbers may vary in both books, my lord. But it is Regulation 37A, my lord. Part 1. May I just read out, my lord?
No, it says or.
Yes, ma'am. 37A, an officer who is retired from Air Force service on account of disability which is attributable to or aggravated by such service and is assessed as 20% or over may, on retirement, be awarded a disability pension consisting of service element and a disability element in accordance with the regulations of this section.
With the appendix 2. In between services. My lord,
My lord,
kindly
Appendix 2, my lord, to this pension regulation is a list of diseases, my lord. That, my lord, at 1961 was guided by this thing, my lord, this list, my lord, but now it is guided by the GMO, Guide to Medical Officer.
So this onset is after the accident or prior to the accident?
This is of 2008, my lord, that is
CAD?
after the accident, my lord. Accident was in 2001, my lord. My lord would kindly appreciate at that time also I was posted in peace area, my lord. But in AR, my lord, nothing is peace, my lord.
We can say peace area. It is aggravated by service.
The GMO, my lord, the Guide to Medical Officer, my lord, the list of diseases.
Can you give us a copy of this?
My lord, I shall provide, my lord. I shall provide.
Just give us a copy of this.
My lord, by today I will make a Xerox, my lord. My lord, only one thing, my lord, in GMO, my lord, but the list of diseases is there, my lord. There is no mention of CAD, my lord. The only heart disease that is there is congenital heart disease. CAD is not included in the list.
What does that mean?
That means that, my lord, according to the respondents, there is no such disease named CAD that can occur, my lord, to a person serving in the military or air force. That, Lord, I most humbly submit this.
But how a congenital disease can be attributed to a service? Cannot be.
Well, that only one thing as per the respondents, well, as per this book, it has to be either developed in field or CI ops.
Just give us a copy, then
Well,
we'll pass the order. The parties is happening.
Item number 4.
My lord, in item number 4, my lord,
Yes.
Mr. Ujjal Rai is appearing on behalf of the appellant, my lord. Writ petitioner, my lord. He's on leg at court number 16, my lord.
So he's not appearing, he's disappearing.
I was humbly praying, my lord. I beg apology, my lord, for making this prayer, my lord. I was praying for 1 day's accommodation, my lord. He's on leg at court number 16, my lord. My lord, yes. My lord.
Been heard, but your lordship has kept it for all the hearings of the case laws and everything. So, and also there was a direction upon them to serve us certain things, which has not been done.
Comply, my lord, if any, my lord, in the course of this day, my lord. Kindly, my lord, grants me 1 day accommodation, my lord.
Can I just indicate one thing? Your lordship, I don't stand in the way. Some professional colleague is in another, he's standing on his legs in some other place. I don't stand in the way. But the only thing is, at least retain it position as 2 p.m. fixed tomorrow. Because
tomorrow and day after it cannot be.
Let it be in the 22nd.
It can be in the next week. Huh?
22nd. That's on Tuesday. So that is.
Tuesday, anything is fixed. Tuesday, anything is fixed. Tomorrow and day after, we have some original side matters.
No, your lordship. The only thing is, I will indicate one thing. The other day, I was not aware of it. Thanks to my juniors nowadays, they are much more savvy. This entire point about a fixed certificate and all, whether it's from a probation to confirmation, that has already been dealt by a coordinate bench of this court. I'll provide that judgment also. We have notes of arguments ready also, your lordship. So
we'll take it on the next day.
Very well. I just wanted to indicate that it's all there already. Much obliged.
On a prayer. We refrain from passing a last indulgence order normally. You never know what will happen on the next day.
That's all.
I'm good. But sometimes when it gets, when the cup of accommodation is full, then you do it. What can be done?
What's your plan?
Good.
Item number 108.
Your lordship, I appear for the respondents. There was a direction to file affidavit.
Upon you.
Your lordship, we require further 1 week time to complete that. It was a land user matter.
Time for filing the opposition.
Four weeks have already expired. That's why I'm submitting and it was not indicated.
The time for filing opposition is extended by a week from date. List after 2 weeks. In the meantime, may be done.
Time.
Right.
তুমি বলে
দেখি আদার সাইড তো দেখছি না আই এম ফাইলিং মাই এফিডেভিট ইন রিপ্লাই
Yes, taken on record.
একটু নেবেন স্যার
Direction, my lord.
What is the date of death of the employee?
My lord, the date of death of the employee on 15th April 2010, my lord.
15/2.
15th April.
4.
15/4, my lord. Was a constable of WEP, and my lord, he died at the time of his when he was in duty, and from the train he fell down and died.
15/4/2010.
10, my lord. 15/4/2010. Around 19 July 2010, her mother made an application because he was not so literate that she will get a job. He is not entitled. That's why he made an application for her son. As per his requirement, he has no qualification.
Where have you said in the OA that she was not entitled? Show us from the OA. Where have you said in the OA that she was not entitled?
That I have not said. It is.
How you can make such a factual submission?
However, my lord, kindly come to.
However comes later, sir.
My lord,
we are asking you how you can make such a factual submission.
My lord, I have not made that submission.
Then don't say it, please.
My lord, my lord, my lord.
That amounts to
My lord,
a wrong submission.
My lord, subsequently, my lord, subsequently my application was turned down, my lord. That is P4, page 28 to 23.
The only issue is why you should be granted when you were a minor. That is the only thing. You tell us
My lord,
how you will get it.
No, my lord, this has come to its finality previously. That I want to show your lordship. It has come to its finality. They are going to give me appointment. They have taken my written test. They have taken interview. Nothing has been considered by the tribunal.
Even if they have done that, if the rule does not permit, can you get the appointment?
But the three-man screening committee also, my lord,
Three-man screening committee is the appointing authority.
Well, recommended my name also.
So they are the appointing authority.
No, but that.
Therefore, ultimately, your right has to be judged on the scheme. Show us from the scheme that you can get it. That's all. We understand plain paper application submitted within 3 months. Mother has made the application. She was eligible. Still, she has not taken the job. This is the fact. This is the hard fact. You said she was not eligible.
The finding.
But she was eligible. There is no averment that she is not eligible. She has given a plain paper application for her son. After 3 years, he has attained majority. Whether he can get or not, this is the only thing. In the meantime, recommendation, this, that, how is that? If they don't recommend and you are eligible, should you be thrown out? You cannot.
Kindly see only see two judgment only passed by the tribunal.
See,
in previous cases, 2 judgments has been passed by the honorable tribunal.
Yes.
Let's just kindly see.
Anything done contrary to the rule will not vest a right in your favor.
That is
Even if a wrong relief has been granted, you cannot claim parity.
No, I'm not paying priority. In
So
this
therefore, you show that you are entitled. Forget about what they have done in other cases.
In this case, tribunal passed 2 orders previously.
Yes.
Let's see P6.
Earlier they said to consider. This time it has been considered.
P6, page 32 and 35. That has been it has been said that their case has been considered.
Human committee report must be saying that she can.
Page 32 to 35.
Where is the 3-member committee report?
32 to 35. But that report is not with this original application, but that report is in their opposition. R2. Page 17 of the opposition. Page 17 of the opposition, Lordship, kindly see.
वहां पे पकड़ लिया क्या? हाँ हाँ
Is there any report that the mother was eligible? The tribunal has recorded a finding that she was eligible. What is the basis of such finding? Where is your reply which you filed before the tribunal?
affidavit in opposition, your lordship.
You did not file a reply there.
No.
We have not filed.
So here only you have filed. This 3-man committee does not say that the mother was eligible. Is it borne from the record anywhere that she was eligible?
No, your lordship. What's
No,
on
no,
the
no.
record? ছেলে না হ্যাঁ ও ঠিক আছে
Page 91.
ছেলে এটা
91,
ছেলের ও হ্যাঁ yes
page 91.
91 बिजली दे 1
At the time of application.
बिजली दे ना
8 pass.
Your lordship,
हाँ
your lordship should be quarter
And-
pass.
and
Also,
Shibanshu
and Shivangshu the petition.
HS pass
HS pass.
আমি জানতাম না এই একটাই তো ছেলে জানি
group D ছেড়ে দাও সব বলা ঠিক আছে but she didn't apply na
That is the
Ah.
point. She didn't.
এটা পড়ে
eligible हाँ
Yes, sir.
No, I do not know about this document, but it has been,
You know about this document.
Lordship, kindly see only one thing. My lord, when I was at
You have annexed this document with your writ. You say you don't know about this document.
no, I have said, my lord, that that document has been annexed from 2014.
Whenever it is before the consideration,
2014.
then what can be done?
But DG, IG also, my lord, recommended interview was taken, written
Let
test
the
was-
IG issue the appointment letter.
No, that is not.
Therefore, we are saying you are
Yes,
harping on
yes,
something which is not
No,
relevant.
no, Lordship, kindly consider on that.
Making a submission which is not relevant, how it helps you?
Only that aspect Lordship consider.
What aspect? That
Compassionate
cannot-
appointment, my lord.
Cannot
And
be
there is
considered.
one judgment also in the district.
He has died in the line of duty.
Kindly. Yes, my lord. Line of duty.
yes 9 years
Yes, my lord. From
Yes.
falling from 10
हाँ
at the relevant point of time.
less than 10 not exactly 10 during his service
Service. Doing service.
ওটা লেখা
না, না,
আছে
ও ছিল।
হ্যাঁ লেখা আছে
হ্যাঁ।
আপনি লিখেছেন he has written that is what he is saying
Oh, sorry. Sorry.
দিয়ে দিন একটা আবার
দিদি আমাকে শুধু লিখে নিয়ে যাবেন
relevant প্যারাগ্রাফটা বলুন
পুরোটাই
পুরোটা the widow
ওটা লিখে দিন না দিদি এই সোনালি নামটা বলতো সাইটেশনটা একটু লিখে দিন
এটা লিখে নিন 2006 9 Supreme Court cases 190
9 এসএসসি কত
195
Does not apply. The wife had applied. He was eligible. That has become. This does not help you at all. This judgment does not help you at all. And what is the wife's age now?
अब wife का age
She was 37 in 2014.
7
अब 25 9 years
Now she'll be about 48. They are
11
unreserved
years.
category.
exempted category
So 40 years.
62
40 years. No. Cannot.
oh 14
48.
हाँ
40
11
40
years जोड़ो 48 years
48 years
Nothing can.
only breadwinner of the family, my lord. Only they in it consider lordships.
What
and better service will, state will get better service from. Only if your lordship.
हाँ वो तो हमारा लिखी
She is a destitute lady
पैराग्राफ আছে
of a village, my lord.
Sorry, nothing can be done. Yes.
Well, she is a destitute.
Heard
only-
learned counsel
only
for the
consider-
petitioner and the learned counsel for the
Not I'm getting my lord. Lordship tried, but Lordship also tried, but
My lord, I am for the petitioner, my lord. I have prepared the affidavit in opposition in respect to the
You are filing a reply.
reply to the affidavit in opposition filed by the state.
taking instruction from the department, disciplinary authority. But kindly dispose of the matter, directing us
No, my lord,
to
I
complete
want
the dispute proceedings within a month.
My lord, kindly see your lordship's last order, my lord. I want to praise this proceeding, my lord. The first order dated 10/6/2025, my lord. In view of paragraph 7, they have filed the opposition.
So 6/11/2012 remains intact. There is no.
And but we want to complete the dispute proceedings within 15 days or 20 days, whatever may be.
Who is stopping you?
No, but he's not cooperating with the department. Last year, I received one email on the last 14th of July in the night.
He is not cooperating.
Yes.
No, don't give that. You have already filed an opposition.
Yes,
Let us see.
already filed it up.
Let us see from the opposition.
Lordship, kindly consider their opposition.
Let us see.
Yes, Lord.
In the opposition, anything in particular you want us to see?
What are the charge framed against him? And charge sheet has been issued. Dispute proceedings has been started. In the meantime,
Only issue is continuance of suspension.
Suspension.
There is nothing else.
That is only. And pending dispute proceedings. We have been instructed that we want to complete the proceedings within 3 weeks or 4 weeks, to whether he will be acquitted, discharged, or whatever may be there. And also, if he is discharged, there will be no.
Why the authority is so eager to keep him under suspension?
Because not a serious charge against him.
So every serious charge has to be, the employee has to be suspended.
No, what insubordination.
Whatever it is, there is a requirement under the extant provision that you have to assess and pass an order why he has to be continued. You could have done it. Who stopped you? You have not done it.
So another thing I want to draw your lordship's attention to paragraph 2 of my application, writ petition, lordship. Kindly consider this with their reply in paragraph number 6 and 7 of their opposition. They have decided, definitely Lordship, they have consciously decided to not to answer to paragraph number 2. They have not answered anything on paragraph number 2. Lordship, the eagerness of the state may be because of this to complete.
Para 2 of?
Para 2 of the petition, my lord.
Writ petition.
It's writ petition that the petitioner states that Superintendent of Police Bankura, as desired by the Additional Director General of the Police, West Bengal holding the additional charge of the Inspector General of the Police, West Bengal directed your petitioner to show cause as to why departmental proceeding should not be drawn up against your petitioner for his gross misconduct, insubordination and indisciplined conduct, unbecoming a member of the discipline force for proceeding on leave despite denial of permission. Your petitioner duly replied to the said show cause notice and the respondent authorities being not satisfied. Now, Lordship, kindly come to their opposition. Why I want to indicate this, Lordship? Because of the word desired. Lordship, the matter, though it is not at this stage to be adjudicated, but Lordship, kindly take note of this.
But this is nothing at the moment. This is
I
just
make
a
any
statement
comments on
of
the-
fact. What is there to deny in this?
So I just want to because the
This is not
delegation
there.
as
None
desired.
of this is in dispute.
Yes, my lord.
According to you, there was no direction of the Additional Director General.
Whether this direction can be given, it's a quasi-judicial exercise of the power, my lord. That is the further concept.
SP is your disciplinary authority.
My lord, my disciplinary authority is the appointing authority. That is Lordship, the IG, the Director General.
Correct. Therefore, we are saying Superintendent of Police is not the disciplinary authority.
Here, Lordship, what is
So he must be acting under the direction of the disciplinary authority.
Whether he can delegate it or not, that is the question. But not at this stage.
For
to
issuing
decide.
a show cause.
No, Lordship, I don't want to harp on this. That can be later
Whether
decided.
ultimately, if charge memo is issued by a competent
Then-
authority, then an issue may arise.
Yes,
This
I
is
want to
just a
confine
show-
myself within the contour of the.
You are here only for the
For
issue
the-
of suspension.
Yes, my lord.
Whether that is to continue or not.
Yes.
How long it has continued?
My lord, I was suspended, my lord, on
15/7/24.
Yes.
So 1 year.
1 year, almost 1 year.
And the first review after 3 months, and the second
First
review was to be done after 180 days.
180 days.
Means
That is
6
as per the
months.
rules. Yes, my lord.
That is as per the rule. There is no review.
And no speaking order also.
And where is the order passed pursuant to the 180 days review?
Yes, my lord. Coming. Lordship, one is page 68. And
No, the one after 180 days. 13/3/25.
My lord, yes.
No, it must be of a later date.
First few.
Page 46, another suspension order, 15 July 2020.
46.
46.
15/7/2024.
Every page has 2 pages, 3 pages numbers at the top.
From the
Becomes impossible for
yes,
18, then 46, which was the correct.
the
minor concurrence.
yes, 15/7/2024 during the suspension period, he will draw. Lordship, this was decided. Ramesh Chandra Hajra, Inspector of Police, presently posted as Inspector of Police, Bankura District, is hereby placed under suspension with effect from 15/7/2024 a.m. pending inquiry into his conduct in the departmental proceeding, as his continuance in service is prejudicial to public interest. During the suspension period, he will withdraw half of his basic pay and admissible allowances. During this period of suspension, this was the first suspension. Thereafter, Lordship.
15/7/24.
Yes, my lord. That is the order of
No,
suspension.
that is the 3-month one. We are asking where is the one after 180
Thereafter,
days?
my lord, I'm coming to.
17.
Now this has no relevance. (17.3.25).
My lord, I'm checking it, lordship. Lordship, one is 16/11/2012. This was the constitution of the review committee. After that, lordship, this is on the 13/3/25, lordship.
17.3.25.
17/3/25.
By a covering letter of 17.3.25.
I got the copy. This discussion is given in 67. Copy of the said report.
In terms of the order of 17 January 2025, page 63.
And this starts from 67 is the discussion. May I read it, my lord? In compliance with the order dated 17/1/2025 of the Honorable West Bengal Administrative Tribunal passed in connection with OA number 638 of 2024, meeting of the review committee constituted as per the directions of the Honorable Tribunal was held on 13/3/2025 at 12 hours in the office chamber of the Additional Director General and Inspector General of Police, Law and Order, West Bengal, and holding additional charge of Inspector General of Police, Headquarters, West Bengal, at Nobanno, second floor, 325 Sharad Chatterjee Road, Shibpur, Howrah, to review the suspension order dated 15/7/2024 concerning Sri Ramesh Chandra Hajra, formerly Inspector.
Yes, you are reading page 67.
67, my lord.
We have seen it, don't.
Yes, my lord. Then discussion and decision. Kindly come to discussion. Copy of the status report of Sri Kumar Gautam, IPS, Inquiry Officer, Police DIB, suspension order, and after considering all aspects, what is the reason to continue with the suspension? Again, the matter will be reviewed after 180 days if necessary.
Yes. Third
Your Lordship, I am appearing for the petitioners in this matter, Your Lordship.
Dheeraj.
Your Lordship, I was praying for not today, if it could be taken up tomorrow or as your Lordship's convenience. Amrita Pandey is appearing in this matter. She's not in court today, Your Lordship. She has left.
Thank you.
Not today.
Much obliged.
At 12 and 13.
112.
My lordship. My lord, last day, your lordship posed me a question which I could not answer. My lord, I humbly submit that, but this is in the order. That how am I aggrieved? This is in the order.
Yes.
If your lordship kindly let me 1 minute, I can show from the order itself.
All right. No. We don't believe in curtailing an optimum time.
No.
We never believe in curtailing any optimum time. You tell us what you want to tell us.
My lord, in the order, there are 3-4 lines by which I have been aggrieved, but the main line, my lord, if your lordship kindly comes to the last page of the order,
Yes.
and just my lord, last paragraph, the last but the first above paragraph. The tribunal has also observed that a certificate was initially suspended and cancelled later was again re-registered after payment of some penalty. Such acts of the respondent authority were arbitrary and whimsical. Validity of a certificate once accepted cannot be questioned at a later stage. My lord, this is absolutely wrong. We did not, first of all, my lord, it was not re-registration. It was done absolutely fresh registration. And my lord, there are other lines also, my lord, against us, my lord. If your lordship kindly let me, my lord. My lord sees, my lord, the inner page 4 of the judgment, second paragraph. Inner page 4 of the judgment, second paragraph. If I may read, my lord.
The tribunal
observes that on one hand, the registration certificate was cancelled on the ground that the applicant was in possession of a dual certificates, and after such cancellation gives an opportunity to the applicant to register her qualification. This is not so, my lord. And my lord, even though temporarily under the same parishad which had cancelled the certificate, it is surprising to the tribunal. The board on one hand cancels the certificate on the charge of dual possession of certificate by 2 different council, and on the other hand also allows the applicant to register with it even though temporarily. This is also incorrect. The next paragraph. From this observation, it can safely be assumed that the Parishad has no objection if the applicant continues to possess 2 certificates, one from Maharashtra Council, the other one from Parishad. But this is not so. We vehemently opposed. And my lord, if your lordship allows me to go into the merit, I will let you know. I will try to impress upon your lordship that we have never supported the dual registration, and this dual registration, which is temporary and afterward, this is also by virtue of the statute which came afterwards, my lord.
You are respondent number in the writ petition?
Well, I am the. No, I am. But, so far the writ petition filed by the state, I am the respondent number 2, my lord.
2.
Yes, my lord.
Registrar,
my lord. And in the another writ, my lord, we are the writ petition.
and you were a party in the tribunal also.
Yes, my lord. We were, my lord.
But the state has preferred the writ petition.
First we preferred, which is 81. Thereafter, my lord, the state. To my humble.
So where is your reply filed before the tribunal?
My lord, so far the reply is concerned, my lord, there was this document which is in a manner of humble submission, written submission was submitted, my lord.
This is what you had filed.
This is at that time, my lord. I am candidly submitting. I am candidly submitting, my lord.
Don't give us 1 copy, please.
My lord, 2 copies. I'm extremely sorry. I'm extremely sorry. এটা তোমাদের ছিল না 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 অ্যানেক্সের ওখানে দেওয়া ছিল আচ্ছা আচ্ছা অ্যানেক্সের it was there. No, my lord. No, if your lordship sees the there annexure is written in the petition itself. একবার একটা কপি দাও আমাকে। আমি শেষ। But we have annex this document. There is no mention of the annex.
Page
81 of the WPSC 81. It's a page 106. এখানে তো আমাকে বলে দিতে রেখেছি।
এটা কি হয়েছে এটা দেন
Just a minute, just a minute.
কোথায় আছে
In
গো? কোন 81?
WBST
দাদা 81 এ
101, where is this written, sir? There is no written submission. It's only in 81. 81 at page. So we'll go by that, not take this.
My lord.
Since it is on record, why?
My lord, no problem, my lord. Absolutely, my lord. What I say, my lord, these documents
We'll
were-
look into it, don't worry.
My lord.
Maybe it will be sufficient, we don't know. Page.
This is not the
I understand. I'm tendering the আমাকে যেটা দিয়েছে হাতে আমি সেটাই দিয়েছি আমি এটা দিয়েছি আমি সেটাই দিয়েছি Why should I? I tender apology. Yes, আমাকে শুধু না স্টেটকেও তো এটাই দিয়েছে দাদা তোমাকে তাহলে এটা কাঁচা কপি মেবি পরে হয়তো ওটা দেওয়া হয়েছিল আই হ্যাভ নো আইডিয়া আমি সত্যি জানি নো আইডিয়া ট্যাব কোথায় গেল ট্যাব কোথায় গেল এখানে রেখে দিচ্ছি
Does she have a NCISM registration?
She did not have. NCS, it came much later, my lord.
It came in 22. What do you mean much later?
My
What
lord,
is the date of advertisement?
My lord, kindly can you see?
It's 22, my lord.
NCSA में जो that registration, my lord, that act was
What
came
is
earlier. Okay.
What do you mean later? It came in 22, February 22. So what is the date of advertisement? Advertisement is prior to February 22.
12 Feb 2022.
Huh?
12 2022.
So much after that, what do you mean?
My lord, the act, the regulation of the registration, this is by the NCSA regulation, which came after. In between the transition period, it was guided by CCIM regulation.
Don't say after and before. 6/2/22 NCISM has come into existence. The advertisement is of 12.
Yes, my lord.
10 months, 10 months thereafter. So till that time, there was no registration with the NCISM.
No, that registration was by the CCIM registration was continuing.
Till which time?
2023, till the NCISM regulation came into
What is
effect.
the date of the regulation?
Regulation came into effect, my lord, 2023. রেগুলেশনটা দিন তো একবার কত 29th December 2023.
So till this date, it was being done by CCIM.
CCIM, yes, my lord.
So she had a registration with CCIM.
No, that was CCIM registration, my lord, subject to your lordship's acceptance. The registration was, in a sense, my lord, state, there are two kind of registration was permitted by CCIM Act. I can show your lordship. Is one through state and another if the candidate herself applies. She never applies for CCIM registration. Her registration was CCIM was to state registration. And once the state registration cancelled,
because of her registration with the Paschim Banga Parishad.
yes. So by default, if the registration of Paschim Banga Parishad,
what is the date of advertisement?
Advertisement date? 12th December 2022.
Which December?
12th December 2022.
And the last date for submission of this?
31st. 30th
Yeah,
December
2022.
2022.
So where is the advertisement? Let us see the advertisement.
My lord. Advertisement runs from, if your lord, my lord is seeing 81. My lord is seeing read petition 81 or 101.
Whatever you want, we can proceed.
My lord, 81 is mine one. If your lordship kindly take it up.
Yes.
It's page 51 in
From running page 51, it is, my lord. Advertisement. আমাদেরটা দেখে নাও 81 টা Your lordship finds the page number 51.
Yes.
Second paragraph, only online registration application will be allowed between 16/12/2022 from 10 a.m. till 30th December 2022 till 2 p.m.
That is not the issue. That is the issue.
And so for the registration criteria, it is on the next page. Essential criteria for registration, my lord, page 52. Point number 2, note. That is why it is also written, my lord, kindly see, my lord, note, the registration must be with CCIM, Central Council of Indian Medicine, not NCISM. Because at that time, registration.
So there was an option either Paschim
Either,
Banga
yes,
Parishad
yes.
or the CCI.
Absolutely, my lord, absolutely. There was an option. Had she, my lord, possessed the CCIM registration even, that would have sufficed, but it is not so.
So what we are required to see is only whether you had a registration between 16/12/22 and 30/12/22.
Only thing, my lord, what I get from this writ petition is this, my lord, this order of suspension of my registration and my lord, thereafter cancellation. My lord, let them show a single paper by which they can show it has been served upon me any point of time. But it was only served, only I came to know about the suspension and my lord, cancellation at the time when my lord, this my lord, authentication of documents were asked to be, authentication was required to be done by the Health Recruitment Board. My lord, prior to that, my lord, neither any, I have taken specific instruction from my client whether this suspension of the registration was ever served upon you or not. But she categorically said no, never it was served upon me. My lord, if your lordship allows, my lord, even in the
Again, we are asking you in between 16/12/22 and 30/12/22, which registration you are relying upon? Show us.
16/12/22 and
That it stood cancelled behind your back comes later. First, show us what is the document that you are claiming the registration.
as a look. বলবো?
Because you were required to upload these documents, you must have uploaded. It was an online application.
It was online application.
Must have been required to upload.
Yes,
it.
that is also noted in the tribunal's order.
Must be, that is the
That
normal.
she has that she has uploaded that registration.
So which registration you have uploaded? First show us that, then we'll see whether it was cancelled properly or not.
2014.
My lord, your lordship may find, my lord, page 34, if I'm not wrong, my lord, page 34. It was the renewal certificate.
No, no. No, it's not. Common certificate.
34 is the affidavit page.
No, no.
71, sorry, my lord, 71. Page
71.
My lord, it's a right-hand side, pages are marked.
So you're relying on this one.
Yes, my lord, I have uploaded this one.
This is by the Paschim Banga Parishad, not by CCIM or NSIC.
Right. My lord, in the application form, they have cited, my lord, it speaks of Paschim Banga Ayurvedic Parishad. So, my lord, this is the renewal. So, in all likelihood, my lord, this is the certificate she must have uploaded.
This is the certificate, absolutely.
This is the certificate she must have uploaded, my lord.
So now, after you participated on the strength of this certificate, you have been excluded from the process by saying that there is no valid registration.
According to them, my lord, although I have qualified.
According to them only, that is the case.
Okay, my lord.
So that has brought you before the tribunal. Where is the order saying that you are excluded by virtue of this fact?
I'm coming, my lord. That is at page. Order, cancellation order.
The rejection order.
Rejection order, page 172, I guess.
No, no.
172.
If your lordship takes up page 96, 96.
96 is different.
Well, this was annexed with the original application, my lord. My lord, your lordship will find an order dated 6th of March 2024.
We have got it, yes. So this is an order issued after the verification.
Initially, I was selected, my lord. My name is there in serial number 10 out of 17 incumbents. Verification was called in. I went to the verification. Thereafter, my lord, this order was issued. And in the verification table, my lord, the first time I came to know, my lord, my registration has been cancelled.
Yes, that you have said. Order. So who has cancelled the certificate? You have cancelled. So let us see how you cancelled it. Whether she had knowledge when she was applying or not. That's all we have to see.
Very well, madam. My lord, may I address you on that point? So far, he is my learned friend is saying that the cancellation was not intimated to him or like this. My lord, in the OA itself, your lordship sees there is no indication that she has been never intimated to that. Rather, their challenge is that they were possessing only NCISM certificate. They have never challenged, my lord. But be that as it may, fallen from your lordship, I have to satisfy.
Ultimately, she is being excluded from a recruitment process.
My lord.
If some cancellation has occurred behind her back,
my
then we'll see whether she has to suffer such consequences or not.
What I intend to say that what he is saying here,
He has never stated this before the tribunal. However,
whatever he is saying is the other side
My
of the
lord.
same coin.
My lord.
If he has a registration here, then he has a registration there. So therefore,
Yes.
the nomenclature is irrelevant.
My lord, then may I try to impress upon your lordship that how we had done this and in the process that we followed. And my learned senior has also, my lord, shown your lordships the reminder letters that we have sent to her, and my lord, which is, my lord, officially sent. And my lord, I have
Bank
also,
on our memory.
not my lord. My lord, I am referring those documents. My lord.
Yes.
Kindly come to page 170 of my writ petition, my lord. It is first, my lord, 169. This is the, my lord, suspension. 169. First, my lord, we suspended as we got the information that she is having the, my lord, the dual registration. Then, my lord, the first reminder on 21st/02/2023. Then, my lord, the second reminder in the next page, 24/03/2023. Then, my lord, we cancelled. No, these have not been challenged. And my lord, one thing, if your lordship kindly takes into consideration, when she has got her registration in Maharashtra Council, much before that, she never cared for this, my lord. She never cared for this because she was practicing over there.
They have suspended it.
She also, lordship, admitted and lordship, she has also admitted that at time of verification she has failed to produce the West Bengal registration number.
What is the rule that one cannot have dual registration?
My lord, my lord.
One cannot possess dual registration. That is
The dual registration, my lord, so far the other fact is concerned. Section 29, they have, my lord, they have invoked. Section 29, my lord, if your lordship kindly sees.
No, his lordship wants
My lord,
to
kindly sees section.
why and under which provision there
Yes,
is a
yes.
bar to registration in two parishads.
My lord.
Where is that bar?
My lord. So far the present rule is concerned, this is there. So
No, on 21/11/22.
Yes, my lord, I am coming.
When you took the action to suspend, where was the bar?
My lord, the bar was that, my lord, she had to inform her registration address, and that is mandatory. My lord, I'm showing your lordship. This is the rule, 1982 rule. Arekta copy, দিন, 1982 আরেকটা copy, 1982 এই রুলটা first considers the Act of Paschim Banga Ayurved System Medicine Act. Malad first considers this Act, where it is specifically stated in 24(3). Kindly turn to page section 24. My lord. 24C. The address must be communicated, has to be communicated. And also, my lord, the certificate of registration that also tells that any change in the address has to be communicated forthwith. But she has not done this. And Rule 26 of 1982, my lord, I'm sorry, my lord, I have only one copy of this. I am extremely, I'm tendering my apology. It also says that it makes it mandatory upon a candidate to inform the state board about the change of address. The Paschim Bongo Act says the address has to be stated, and regulations, CCIM regulation also state if any change of address has to be immediately, my lord, informed. Nothing has been done, and that is why, my lord, under invoking section 29 of PBAP Act, it empowers the Parishad to remove a person's name if any entry has been done fraudulently. And my lord, there is also provision for appeal even. If there is any, if a person is aggrieved by any decision. And my lord, one line, my lord, they have relinquished their certificate before they took up Maharashtra Council, which is noted by the learned tribunal. কত কথা বলতে কত কথা ওটা কোথায় হুম হুম
So we could not find a bar that one cannot be registered with two parishads.
My lord, only one thing, my lord, kindly turns to, my lord, page 2 of the order, tribunal's order.
No, that is before us.
Very well, my lord. so far the bar, express bar is concerned, as you've fallen from your lordship, that no person can be doing this. This came later in NSA as a specific bar. But it was done, my lord, in a sense.
We have to see the position as obtaining in November, December 22.
But the November,
It's
December
only
22,
relevant.
November, December 22, no person were allowed to do that because of that provision, my lord. That registration address has to be immediately done. And my lord, that with and registration certificate also says, there is also provision in the certificate in the backside, your lordship checks, that every candidate has to be immediately state any my lord, change of address.
And if he doesn't do, then what has to be done?
Then they invoke section 29.
How can this?
Because that amount, my lord, section 24 says
29 is a very limited power. If an entry is wrongly made or fraudulently made.
My lord, that
just because somebody changes the address, it will not
I understand, but that is they used to do because
cannot. The act is very specific.
But the thing is,
the maximum fine prescribed is 50 rupees.
My lord, it is 61 act, my lord.
So
that is the thing.
This is the provision that has to be followed. And even if he is not registered or he or she is not registered with the Paschim Banga Parishad,
yes,
and registered with Maharashtra
Council, yes,
then ipso facto she is registered with CCIM. So one of the qualifications he will fulfill. But you have not cancelled the Maharashtra registration.
I cannot, my lord.
You cannot,
Yes,
obviously.
obviously, my lord.
So therefore, how she has been disqualified?
My lord, so far the Maharashtra Council is concerned, my lord, we are not about whether through that they have any CCIM registration. Because because, my lord, subject to your lordship's acceptance, my lord, the act is very specified. CCIM registration.
Not relied on the Maharashtra registration.
They have because they have stated
They have
that
relied
before the
on
tribunal.
Paschim Banga one, but that's immaterial. There is no power to cancel because of a change of address or a subsequent registration. The act does not provide. There is no source of power.
My lord, they have
any authority to do this. How he can do it?
My lord,
your act. How do you sustain the order? The section 29 is only an entry in which is proved to the satisfaction of the Parishad to have been fraudulently or incorrectly made. Nobody has alleged that she has made the registration fraudulently or incorrectly.
But she was registered with the Maharashtra.
Yes, so that is not fraudulent or incorrect registration.
But she cannot obtain.
Where is the bar? We are asking him, we are asking you, show us the bar.
My lord, she has also relinquished her certificate, my lord. That was
the
submitted.
tribunal says so. Yes, we
That
have
was
understood
submitted by the.
because the tribunal says so. We have understood.
They
what
have
you are saying.
submitted.
Yes,
They have.
she can. What's the big deal? She is still qualified. She has a certificate from anywhere. This is a personal qualification. Your registration is for a different purpose. It is to have a role so that you know who are genuine and ingenuine. It's nobody cares that she is not a doctor, having the degree, qualified for registration. She was registered in accordance with law. Nobody's case that she got the registration done fraudulently or incorrectly. 4 years after her registration was valid till December 23. Sometime around 22, 23, she has got a registration done with Maharashtra.
The 22.
Maybe 20. Forget about 22.
April 22.
Maybe 20. So what? Where is the consequence?
My
And who gives you the power to do this?
My lord,
If
kindly,
there is no power in the statute, how can you do it?
my lord, kindly consider only
Where
one
is the
thing.
bar? Where is the power to take such action?
Kindly see page 96.
You cannot run amok like this. This statute circumscribes your power. You cannot run amok like this. If there is a power to do it, you do it. If there is no power, you just sit back.
My lord, only one thing considers.
Yes.
My lord, maybe, my lord, our cancellation is wrong.
Then why should she suffer?
Only one thing.
Yes.
She obtained her registration back in April 2022. My lord, the advertisement came much later.
Yes.
By that time, she has already relinquished the certificate of Paschim Banga Ayurved Parishad. How she can upload, my lord?
There can be no relinquishment unless there is a bar. That you will not get a second registration.
No,
unless you...
if she wants to, she has to relinquish the certificate.
That is what we are asking you. Everything you are saying, and only for your submission, it has to be accepted. Just because it is in the mind of the registrar, it cannot be. It has to be manifest from the provisions. We have gone through the statute. There is no bar in the statute that one cannot have The only thing is once one gets a registration done, they are required to communicate certain details, such as address and all that. You cannot play with someone's future like this. Either the statute gives you a power or it doesn't. There is no power. The limited power for cancellation is in 29 for two limited grounds. Neither of the grounds cover the petitioner's case. If at all, you may have fined her for 50 rupees. If she fails to just see your provision,
My
it
lord,
says,
my lord, may I come back with the instructions?
what instruction?
To that particular thing, my lord.
Nothing. What instruction?
Because my lord, on April she was not having the Paschim Banga arbitration.
Tomorrow.
Tomorrow.
Not today.